and leave to mention on matter, Lordship, today's list, item number 43, Lordship. Your Lordship yesterday heard the matter and fixed it on 27th February, Lordship. Instead of that, the matter is appearing today's list, Lordship. Item number 43 of today's list, Lordship. Your Lordship yesterday passed the order, Lordship. The bank matter, Lordship, and leave to mention on matter.
43
Lordship.
এটা রিপিট হচ্ছে কেন?
ভলিউমটা মিউট করো।
It is supposed to be
27th February.
27
43.
27
27 February.
কত চলছে?
Please check whether 43 is on 27 or not. All right, it will be taken care of.
Why not? Yesterday, item number 25 fixed on March 4th March, but list today listing
Item number
4.
item number 4. Raghunath Shaw. It is supposed to come on
March 4th March.
কালকে এটা করেছে? We shall check. Yes, call the list.
Item number 28.
1 2 টা এখন নেই না?
28.
28 I have for the petition. Here, as per his lordship direction, manner, I send the copy by registrar speech post. But the registration receipt, manner, I have been displaced from my custody. Although I know they have received it, but they received every service has been misplaced, manner. Kindly, if your lordship direct me to space service within 2 weeks, I will. Even I have got no Xerox also now. If your lordship kindly.
Learned advocate for the petitioner.
And my lord, another thing. Your lordship did not direct subject to law. Your lordship did not direct me to serve the copy upon the government printer. Though I have served, I went to serve, but he stated that he is no more in the panel. Vishwajit Dev. Therefore, I will serve afresh upon the government printer also. Pass that order and within 2 weeks, my lord, it is my fault, my lord. I am paying apology.
The respondents never appeared.
No, my lord. Never appeared. Copy served at the time of moving the motion.
Learned advocate for the petitioner submits before this court that learned advocate for the petitioners that he has misplaced the details of service as directed by this court earlier. It is submitted by him that an opportunity be given to the present writ petitioners to effect fresh service upon the respondents. Stop. In view of such service, submission, the petitioners are granted liberty to serve notice upon all the respondents along with a copy of the instant writ petition.
Government printer also. Fresh.
That includes state also. Just for last line of it. That includes state also under continuation, under speed post with AD, and to file affidavit of service on the next adjourned date, that is on March 7/2024. Stop. Let the matter be listed on the said date, that is on March 7, 2024, under the heading for hearing. So, as an abundant caution, learned advocate for the petitioner is also requested to serve to intimate the next date of hearing along with a server copy of this order to the learned government pleader of this court, and to file a receipted copy of this said letter before this court on the adjourned date.
Grateful to your lordship, extremely grateful.
Next, next,
Item number 29, dismissal থেকে বেরিয়ে গেল তো?
Any-
29 I appear. Secretary আছে। Deputy Service Corps Ministry. Pursuant to the direction of your lordship, it was served upon the office of the learned government pleader. But kindly excuse us, we could not affirm and levy duty service. Documents are there.
the petitioner is represented by his learned advocate. None appears on behalf of the respondents / state. Let the matter be listed on February 12, 2024, under the heading for hearing. Learned advocate for the petitioner is requested to intimate the next date of hearing to the learned advocate for the respondent state by issuing a written notice and to file a receipted copy of notice showing service.
That.
Briefটা নিন। 30. Item number 30.
একটু মানে রান ফর দ্য পিটিশন গুলো। কিছু করতে হবে না। My lord, Mr. Gopal Chandra Das is appearing, my lord, for the corporation, my lord.
And what about the service upon the respondent number 5, that is KIT?
That is also KIT, no, my lord. KIT is not
KIT and substituted private respondent number 6A.
KIT, my lord, is not there, my lord, right now. KIT has been, my lord, KMDA has been merged with KIT.
Very good.
Therefore, my lord, KMs, my lord, on the last occasion, my lord, initially Mr. Dash, my lord, represented that, my lord, he is, my lord,
No.
No.
On 12/12/2023, a direction was passed to inform the next date of hearing to the respondent
that
number
is done. That has been done, my lord.
5 and substituted private respondent number 6A.
Yes. She has also been served. My lord, my lord, may I do one thing, my lord? May I, my lord, inform Mr. Dash once more, my lord? Because, my lord,
But who is the answering respondent?
Mr. Dash, the KMC.
What about the private respondent?
Well, she has also been substituted, and my lord, notice of the writ petition was served upon him, my lord. Served upon her.
Respondent number 5 is Kolkata Improvement Trust.
Well, KIT is not there anymore. KIT has been, my lord, merged with KMDA.
That has been incorporated in the cost title of the.
No. There was, my lord, it was, my lord, never, my lord, the leave was not, my lord, asked for any time, my lord, kindly, my lord, grants me the leave right now, I'll just do it immediately.
Then they are also
They
to
are
be
also
served.
to be,
You have to file an application in the meantime.
my lord, application, my lord, if a leave is, my lord, granted, I can, my lord, incorporate KMDA right now in the cost title, and, my lord, serve a copy upon them, my lord, of the writ petition. Because,
You know the address of the KMDA.
yes.
Ashut. Learned advocate for the petitioners are present. it is submitted by him that during the pendency of the instant writ petition, the respondent number 5, that is Kolkata Improvement Trust, has merged with Kolkata Metropolitan Development Authority. Stop. Learned advocate for the writ petitioner thus prays for leave to correct the cause title by deleting the name of Kolkata Improvement Trust and in its place to incorporate the name of KMD. Incorporate name na korar kore, incorporate the details of KMD. Name and details koro. Name and details of KMD. Leave as prayed for is granted. Learned advocate for the writ petitioner is requested to correct the cause title in court today. Stop. Since the respondents are not represented today, this court proposes to fix the instant matter on March 5, 2024 under the heading for hearing. Stop. The writ petitioners are directed to cause service of notice along with a copy of the instant writ petition upon KMDA under speed post with AD and to file affidavit of service on the adjourned date. Stop para. Learned advocate for the writ petition is further requested to intimate the next date of hearing to the learned advocate for the
KMC is represented, my lord, the corporation.
learned advocate for the learned advocate for the respondent number 1 to 4 as well as upon the learned advocate
My lord, nobody is representing them. My lord. I have to send
as well as to the private respondent number 6A. What I have stated in the last paragraph. Preferably by issuing a written notice and to file the receipted copy of such notice before this court on the adjourned date.
My lord.
Call করি অন্যটা? 31.
My lord, item 31, I am for the petitioner. My lord, in this matter, on the last occasion, lordship directed me to file a supplementary affidavit giving the English translated copy of annexure P3, which was in the vernacular Hindi language.
Yes,
This is
that is ready.
that is ready, my lord. It was affirmed yesterday. My client could come from Uttar Pradesh only yesterday. And my learned friend is not appearing.
Mr. Mukherjee, learned advocate for the Mr. Mukherjee, comma, learned advocate for the writ petition is present. None appears on behalf of the respondents / Union of India. The supplementary affidavit as directed to be filed by the writ petitioner has been filed today and the same is taken on record. Let the matter be listed on.
But my lord, another thing. I am not getting in my file the affidavit in reply. But there was a direction to file the affidavits, exchange the affidavits. Is it on record or otherwise I have to?
Affidavit in reply is in record.
It's on record. Lordship, I may be allowed to get a copy of that.
No, that cannot be permitted. You can take short note of it.
I'll take a
This
short
much you
note.
can.
At the time of hearing, I'll take a short note because I'm not getting in my computer even. I don't think there is any annexure.
No, this is the affidavit in reply.
No annexures are there.
No annexures is there.
I'll take it. I'll have a look and do it.
Very good. কি লিখলাম বাবা? Let the matter be listed on February 27, 2024 under the heading for hearing. Mr. Mukherjee, learned advocate for the petitioner, is once again requested to intimate the next date of hearing to the learned advocate for the respondent / Union of India, preferably by issuing a written notice and to file the receipted copy of such notice on the adjourned date.
If I may see the file, whether the learned, my learned friend's phone number is there in the Vokalatnama, because that will be easier.
ফাইলটা উকিলবাবু চাইছেন দিয়ে দিন। Next.
Seven.
Yeah, I appear for the petition is much.
Who is your other side?
directed.
Yeah, the side here.
দিন ফাইলটা দিন।
দিতে বলেছিল আমি তার সহ গিয়েছি, এটা হচ্ছে লাস্ট কথা। এর আগে নোটিশ দিয়ে দিয়েছি।
Have you intimated the next date of hearing? On 15/12 I have directed. Just see.
Wait a minute.
এইটা নয়। সিভিলটা হাতে ধরে দিয়েছে।
ও আমি ওকে নিয়েছি। এইদিকে ওইদিকে দাঁড়িয়ে আছিস, রেসপন্ডেন্টের জায়গায় দাঁড়িয়ে আছিস।
আগে নোটিশ দিয়েছি। একটা ট্রেনিং করতে গেলাম, ট্রেনিং করতে গিয়ে আমার উইদাউট পারমিশন, কিন্তু আমার ম্যানেজিং কমিটি থেকে আমি পারমিশন নিয়েছি, কিন্তু ম্যানেজিং কমিটি থেকে পারমিশন এলো স্কুল দিয়ে দেয়নি, সেই জন্য এটা হয়েছে। এটা জমা করেন সাপ্লিমেন্টারি এফিডেভিট, ওটা সাইডে সব কিছু দেওয়া আছে।
How do I know that Mr. Shumande, care of Mr. Bhaskar Prasad Boishro, was appearing? Because his name is not appearing anywhere.
নতুন করে
All that we can do is we can serve it on the GP.
That is better.
না না না
Let-
জিপি
হ্যাঁ।
করেছিল, জিপি থেকে ওই নামটা দিয়েছিল, সেই জন্য
Anyway, once more minute, I
Give me some material to show that he has been allotted with this case.
doing material কোথায় থেকে পেয়েছি?
I do not find any vokalatnama of either Mr. Shumande or Mr. Bhaskar Prasad Boishro in this file.
জিপি কে আমি সার্ভিস করেছিলাম, জিপি কে সার্ভিস করতে তখন আমাকে নাম দিল as per
If your lordship fixes a date, we have served the GP. If your lordship,
জিপি কে সার্ভিস করেছিলাম তখন ভাস্কর প্রসাদ বৈশ্যর নাম দিয়েছিল।
if then if your lordship fixes a date, then I'll give them a one more copy, and otherwise your lordship will proceed with this matter.
জিপি কে সার্ভিস করার পর ভাস্কর প্রসাদ বৈশ্যর নামটা অ্যালট হয়েছিল, সেই জন্য ভাস্কর প্রসাদ বৈশ্য থেকে সবকিছু নাম দিয়েছি। রেজিস্ট্রেশন হয়েছিল, সেই রেজিস্ট্রেশনটা হয়েছে ওর নামেই রেজিস্ট্রেশন হয়েছিল, বিজনেস ডিফল্ট হয়ে গেছে।
Yes. The petitioner is represented by his learned advocate.
সব চিঠি করেছি আমি।
On behalf of the petitioner,
তুমি একবার দাঁড়িয়ে থাকো।
one receipted copy of letter dated 5/1/2024
এটা জমা করে দিন, এটা জমা করে দিন, এটা রেকর্ড করে
is filed.
এটা নিলে পরের দিন করলে হবে, পরের দিন করলে।
From such letter, it reveals that the learned advocate for the petitioner has duly intimated the pendency of the instant matter before this court to one Mr. Suman De, care of Mr. Bhaskar Prasad Boisho, learned advocate, stated to be appearing on behalf of the respondents. Stop. In spite of such service, none appears on behalf of the respondent states today. In view of such, comma, for ends of justice, this court fixes the matter on February 27, 2024
ঠিক আছে।
under the same heading.
ভাস্কর
Stop para. Learned advocate for the writ petitioner is requested to intimate the next date of hearing to the learned government pleader, High Court at Calcutta, preferably by issuing a written notice along with a server copy of this order, and to file a receipted copy of the letter showing service upon learned GP, High Court Calcutta.
I'm DP.
এইটা উকিল বাবুকে ফেরত দিয়ে দেবেন, এটা আমরা রাখবো। Yes.
Item number 39.
39, Lordship, I appear for the respondent number 3, 39.
Lordship, so I'm for the petitioners. My senior, Mr. Shomu Mujumdar, is engaged in a different courtroom. Kindly pass a short pass.
Both the writ petitioner and the respondents are represented by their respective learned advocates. On behalf of the writ petitioner, an accommodation has been sought for. Prayer for accommodation is considered and allowed. List this matter on February 26, 2024 under the same heading.
Lordship, great.
Lordship,
I
40.
appear for the petitioner.
Shomu sir and junior of it.
Lord, I
What-
appear.
You are for the,
I'm for the petition. I'm led by Mr. Shomu Mujumdar, sir.
you are also for the petitioner?
Yes, I am. Somo is now leading, my lord,
Okay.
and I am in.
What do you propose to do? Filing.
Yes, my lord.
You will proceed
Yes, my lord, I will.
with your other side.
My lord,
Have you served?
my lord, yes, my lord. This matter, my lord, dragged since 2 years, my lord. And several times that adjournments had
Mr.
been
Daya
taken.
Shankar Mishra,
Mr. Dayasankar Mishra,
on the last occasion, you appeared, no, both of you appeared.
my lord. And once your lordship directed that if
And prior to
respondent
that, you were not, no,
does not appear,
are
my lord,
present.
then matter will be heard ex parte also, my lord. That order.
that is not indicated. That has not been indicated.
In absence of, my lord. That is once such order, my lord.
You are Mr. Srivastava, no?
My lord, no, I am Mr. P.K. Drolia, my lord. I am this
Drolia.
matter, P.K. Drolia, my lord. So let me place my case, my lord. And in the
In
meantime, my lord,
absence of the respondent, it would not be fair.
my lord,
I'm adjourning this matter only for this day.
my lord, keep it on at 2 p.m., my lord. I've been informed. Keep it 2 p.m., my lord, because this bench is not regular bench, my lord. That's why the problem comes.
2 p.m.
2 p.m.
এটা 2 p.m. এ রাখুন তো। Because on the last occasion, both the writ petitioner and the respondents were represented.
My lord.
Prior to that, the writ petitioners were absent on 2 occasions. It happens, which is why I don't want to take up the matter ex parte.
My lord, kindly
All
take up
right,
this
2
matter,
p.m.,
my
2
lord.
p.m.
The widow is suffering since long time, my lord.
I understand your predicament, but try to visualize my predicament also. Please inform and try to ensure the attendance of your other side.
My lord.
এটা 2 p.m. হলো, item number 40, 2 p.m. হলো। Next.
I am for the petitioner, my lord.
I am having for the respondent.
The matter was
All respondent. All respondent. এইটা আছে আমার কাছে।
Exchange of affidavit is complete.
Yes, complete. And my lord, on 8th of August last year, my lord was pleased to hear the matter. My contention was this, that no, my lord, wait, I shall place everything. On that day, my lord was pleased to grant liberty to me to file a supplementary affidavit annexing the copy of the inquiry proceedings. My lord, here, my lord, I am placing the facts.
এখন শেষ হয়নি, আমি লিখেছি উপরে, আপনি আবার শেষ করবেন।
Where is your affidavit of opposition? One affidavit reply is filed. One reply to the supplementary affidavit is also filed. Your affidavit in opposition is not in the file. Have you filed it?
ম্যাডামের কাছে নেই তো অপোজিশন। অপোজিশন তো অফিস কপি।
আমাদের দিয়েছে, সব সার্ভ করেছিলেন, সেই জন্য তো আমরা রিপ্লাই দিয়েছি।
My lord, this BB changed the earlier advocate filed order and not, my lord. I do not know.
But my lord,
Copy is here.
the copy was served on me, and my lord, I filed evidence reply.
That I find.
on record.
In the order sheet, I find that on September 22, 2017, there was a direction for filing affidavit in opposition within 2 weeks after the reopening of the court for puja vacation. Since thereafter, matter was, after 17, matter appeared in my court since 22nd February 2023.
And thereafter, my lord was pleased to hear this matter on 4th of August 2023.
Probably in his absence or in his
No,
presence.
he was present, and thereafter also the matter appeared, and I filed supplementary affidavit. He also filed reply to the said supplementary affidavit.
What do you want to do, sir?
I do not know Kalimar earlier advocate file or which are not.
No, it is not in the file. There is no reflection in the order sheet also, sir.
Kalimar liberty given Kalimar this affidavit affirm, he affirm.
Are you in possession of the copy of the affidavit in opposition?
Supply email.
No, madam, they already supplied me, and I filed reply.
That is there, sir.
So lordship,
So affidavit in opposition is not here, sir. By Monday you will file?
But you 1 week Kalimar.
or lordship, kindly,
He affirm Kalimar, he affirm this affidavit.
no, but lordship kindly treat this copy as their opposition.
I have got no objection.
Copy din.
But Xerox করে একটা copy দিয়ে দেবেন, Xerox copyটাই original
I can work upon the photocopy of the affidavit in opposition. No issue. So let us start.
আবার বি
আছে এটা
না নেই
সাহেব কি করে দেবে?
আমি দিয়ে দেবো আপনার আমার কাছে কপি রয়েছে তো আমি আপনাকে জেরক্স করে
সাহেবকে দিয়ে
কপি
আপনি কোথায়
এই তোমার তোর দেখা
হ্যাঁ আমার প্রাপ্ত হবে
রাখ দিয়ে
Xerox করে নিয়ে রাখছি
এটা জেরক্স করে
এইটা
ওই
Yes, Mr. Lairi.
yes মানে the petitioner
স্যার ওটা একটু জেরক্স
the petitioner was serving as assistant sub-inspector in railway protection force. A departmental proceedings was initiated against him. The charge sheet is at page 50. The allegation is this, that he, along with some other RPF personnel, manhandled one railway employee. Manhandled, misbehaved,
He was posted as ASI of RPF.
RPF.
Writ petitioner is the ASI of RPF. Yes.
A departmental proceedings was initiated against him in 2012, and the charge sheet is at page 50.
In the late evening of such and such, he along with such and such involved themselves in undesirable activities, misbehave and manhandled such and such at such and such place, and insisted him to confess his involvement in connection with theft of solar plate, which was published and he gave wrong statement and entries tied to events. He also filed maintain absolute integrity. Duty and so these three are the charges.
Yes, this is the charge. When I replied to the charges, denied all the allegations. But they held the inquiry.
Very good.
But they held the inquiry. In the inquiry, no presenting officer was appointed. The inquiring authority, in my respectful submission,
63 is your punishment.
yes,
Reduction of 5 stages lower in the present scale of pay.
yes, with cumulative effect.
I understand.
Yes.
And 83 to 85 is the finding of your appellate authority.
Yes. Yes, my lord.
That is also not in your favor, I believe.
Yes.
All right. Inquiry. So the no presenting officer was appointed.
Was appointed, and my lord, on the last occasion, I submitted that, and in the petition I have made categorical statement that the inquiring authority, he examined the witnesses for the departmental authorities. Total number of witnesses was 9. He examined the 9 witnesses and he cross-examined the said 9 witnesses.
Cross-examined?
Yes, he cross-examined. And my lord, that my clear statement in my read petition, and that was not denied by my learned friends, in opposition. And my lord,
I believe in the supplementary affidavit you have shown, no?
No, my lord, I am coming now. And my lord was pleased to grant me liberty to file the supplementary affidavit annexing the copy of the proceedings. Well, that supplementary affidavit I have filed, and they have filed reply to that supplementary affidavit. Lordship, kindly see for a moment my supplementary affidavit, which has been filed, that is affirmed on that is affirmed on 9th day of August 2023.
Yes.
Yes, my lord, kindly see page 5 of the say supplementary affidavit. That is the copy of the proceedings. Then, my lord, please come to page number 10. The prosecution witnesses examined.
Yes.
He examined the 9 prosecution witnesses.
But he cross-examined?
Huh? Yes, my lord, I am coming. Then the documents exhibited. Then, my lord, kindly see for a moment. Next page, page 11.
Yes.
Page 11, middle, prosecution witness number 1. This is the examination. Then, my lord, cross-examination by the delinquent. The delinquent Sheikh Korim, ASI, declined any cross-examination. Then, my lord, cross-examination by the EO.
So, Mr. Larry, according to you, the inquiry officer examined the prosecution witness himself.
Yes.
And he again cross-examined him.
Yes. That is on record. And he cross-examined all the 9 witnesses.
Mr. Larry, is there any bar by the inquiry officer to put question to the witness? I believe no.
No, yes, my lord.
What I am on, Mr. Larry, inquiry officer can put any question to the either to the prosecution witness or to the defense witness.
Yes, but that is for the purpose of clarification. Yes.
But here he also cross-examined the same witness.
The same witnesses whom he examined. And on the last occasion, my lord, I placed before my lord.
This principle of natural justice has been violated.
And my lord, the questions he put in cross-examination, they are leading question, and also which suggests that he acted as prosecutor.
In the relevant act or in the relevant statute, there was no provision for appointment of a presenting officer.
No, my lord, in the RPF rules, there is no provision for appointment of presenting officer. But I placed before my lord Supreme Court judgment that is reported in 2008, volume 7, SCG, page 670.
Yes, what is your reply? How we can cross-examine this self-same witness? What they have stated, give me a copy of their affidavit in opposition.
In their reply to the supplementary affidavit,
Yes.
that is on your They have not denied.
In your reply to the supplementary affidavit, kindly come to page number 3 of your reply. It is stated from the top, it is stated that the enrolled member of the force of RPF is governed by such and such rules, and disciplinary proceeding is initiated against the member of the force on the provision laid down in such and such rules, and there is no provision to appoint presenting officer. Very good. However, as per provision contained in rule such and such, the charged officer is allowed to take the assistance of any other member of the force where, in the opinion of the inquiry officer, may at the request of the party charged put his defense properly. But this is not the case of Mr. Lyry. Mr. Lyry contends that your inquiry officer examined the question. To some extent, that is all acceptable. But how your inquiry officer cross-examine the self-same witness?
Yes.
I believe that is the objection raised by Mr. Lyry.
Yes.
And according to Mr. Lyry, your inquiry officer acted as a prosecutor. Please hand over the copy of the affidavit in opposition they have filed. No, it is with the Mr. Lyry.
Yes, madam. My copy they have taken for getting because for their copy there is some
What is your answer to the effect? Is there any rule that inquiry officer can examine the witness and again cross-examine the self-same witness?
Yes, my lord.
Examine and cross-examine by the same person.
No.
How could it be? When cross-examination has been declined by the charged officer, how your inquiry officer can cross-examine? It is not in the Evidence Act, not in accordance with the principle of natural justice.
And
Ashun.
Next day, I am not submit Kalimar next day.
No, what more? That is nothing to be
and
some
my
more.
lord, my lord,
Show me the rule, I shall pass appropriate order.
my lord,
Kalimar, there is no provision to the appointing the presenting officer. As the rules of 150.
So far as presenting officer is concerned,
on-
Mr. Lyde is not raising objection. Mr. Lyde is raising objection under which rule an inquiry officer can examine a witness
Yes, sir.
and cross-examine the self-same witness. That is Mr. Lyde is asking.
and my lord, on the same acts of similar
Not
act, my lord,
Ashun.
wait, my
Kalimar,
lord,
Hari Part Kalimar, next day I submit.
No.
there is a judgment of
By
honorable
Mr.
court.
Lyde, I don't require it. By
Yes,
learned advocate for the writ petitioner, Mr. Lyde, learned advocate for the writ petitioner. Your good name, sir?
Oh,
Your good name? And Mr. Das, learned advocate for the respondents, Ayodhya is present.
very, very important, sir.
আমাদের এটা করে অপোজিশন আমাদের
Stop. At the very outset, it has been submitted by Mr. Das that the affidavit in opposition as directed to be filed is somehow misplaced from his brief, though copy of which has been served upon the learned advocate for the writ petitioner. Stop. In view of such, this court granted liberty to file an authenticated copy of the affidavit in opposition for avoiding any further delay. Stop. In accordance with the request as made by this court, Mr. Das has handed over an authenticated copy of the affidavit in opposition and the same be taken on record. Stop. This court has heard Mr. Lyre, learned advocate for the writ petitioner, and Mr. Das, learned advocate for the respondents / Union of India and its officials at length. Stop. by filing the instant writ petition under Article 226 of the Constitution of India, the writ petitioner has prayed for issuance of writ of mandamus directing / commanding the respondents to withdraw / revoke / cancel and / or rescind the order number 272 / 2015 dated 3930.09/2015 as passed by the respondent number 3 and the order dated 9/1/2017 as passed by the respondent number 2, whereby and whereunder the present writ petitioner was awarded punishment to the extent reduction of 5 stages lower in the present scale of pay. সেটা পেজ নাম্বার 63 থেকে এই যে যতটা আপনার বোল্ডে আছে। Stop. In course of his submission, Mr. Lahiri at the very outset draws attention of this court to the memorandum of charges as leveled against the present petitioner, which has been annexed, a copy of which has been annexed with the mark P1 at page 50 of the writ petition. Attention of this court is also drawn to the finding of the inquiry officer being annexure P2. I'm sorry, not P2. Where is the finding of the inquiry officer, sir?
That is annexed to the supplementary.
Oh. Finding of the annexure that you have annexed?
Yes, my lord. Page 10 of my supplementary evidence. Page 10 of not page. It starts from page 4, annexure X.
Page?
Page 4 of the supplementary affidavit, annexure X.
Page 14. Being annexure X to the supplementary affidavit, comma, the punishment awarded by the respondent number three, being annexure P5 of the writ petition, and the copy of the finding of the appellate authority being annexure P10 to the instant writ petition. Stop. Paradigm. It is further submitted by Mr. Lahiri that while conducting the departmental inquiry, no presenting officer was appointed by the authority. Stop. However, from the minutes of the inquiry, it would reveal that the inquiry officer not only examined the prosecution witnesses, but also cross-examined the same prosecution witnesses in utter violation of principle of natural justice, which seriously affects the merit of the disciplinary proceeding. It is submitted by Mr. Lahiri that in a departmental proceeding, an inquiry officer is supposed to act impartially, and in the event it is found he acted as a prosecutor, it can be safely contended that the said inquiry officer acted with utter biasness. Mr. Lahiri thus submits that on the aforesaid two grounds, the instant writ petition may be allowed by setting aside the impugn orders of punishment.
My lord, on submission kind order, one judgment supplied by the petitioner, and my lord, have. Page 675. Paragraph 18. Judgment.
On the last occasion, when I said,
Judgment, paragraph 18, page 65 and 19. 675 page.
675.
Paragraph 18 and 19. Well, this is my submission. Can you record it?
Yes. Per contra,
18 and 19. Recorded submission.
per contra, in course of his submission, Mr. Lahiri places his reliance upon the reported decision of Union of India and others versus Ram Lakhan Sharma, reported in 2018, volume 7, SCC 670. Stop pal.
and my lord, no.
Per contra, Mr. Das, learned advocate for the respondents, draws attention of this court to the authenticated copy of the affidavit in opposition as filed today by him in court. It is contended by him that attention of this court is also drawn to the reply as filed by the respondent state as against the supplementary affidavit of the writ petitioner. It is contended by Mr. Das that from the minutes of the inquiry proceeding, it would reveal that the writ petitioner was given opportunity to cross-examine the prosecution witnesses, but he had not availed the same for the reason best known to him. Stop. It is further contended that as per provision laid down in Rule 153 of RPF Rules 1987, there is no provision to appoint any appointing officer, and there is no provision for appointing any presenting officer. Stop. It is further contended by Mr. Das that, however, there is a provision in the said rules, being Rule 153.8, that the charged officer may be allowed to take assistance of any other member of the force. Stop. Continuation. It is further argued by Mr. Das that on close scrutiny of the entire minutes of the inquiry proceeding, it would reveal that there occurred no violation of principle of natural justice as wrongly claimed by the writ petitioner, and therefore the instant writ petition may be dismissed in limine. Stop. This court had, Mr. Das, Mr. Das, learned advocate for the respondents, in course of his argument, also places his reliance upon paragraph 18 and paragraph 19 of the judgment of Ram Lakal Sharma, Supra. Stop it. On perusal of the entire materials as placed before this court, and after hearing the learned advocate for the contending parties, it appears to this court that it is the grievance of the petitioner before this court that in course of the departmental proceeding, in course of the departmental inquiry proceeding, the inquiry officer had violated the principle of natural justice, and he has also acted with utter biasness in view of the fact that the inquiry officer not only examined all the prosecution witnesses by himself, but he himself also cross-examined the some witnesses. Stop there. According to the writ petitioner, such an act on the part of the inquiry officer tantamounts to an act of a prosecutor, which the inquiry officer is not supposed to do in order to show his fairness in conducting the inquiry. At this juncture, this court proposes to look to the relevant portion of the reported decision of Ram Lakhan Sharma and those are reproduced herein below in verbatim. Set out paragraph 31 to 34 এর this portion. 32 to 31 to 34 this portion. In view of the proposition of law as enunciated in the case of Ram Lakhan Sharma, it thus reveals that while conducting a domestic inquiry, conducts regular examination chief by leading prosecution witnesses through the prosecution case, as has been done in this case also, or cross-examine the defense witnesses, or puts suggestive questions to establish the prosecution case employee, as has also been done in this case. The inquiry proceeding stands vitiated by such conduct of the inquiry officer. On perusal of the entire minutes of the inquiry proceeding, it reveals that though the inquiry officer had given sufficient opportunity to the delinquent to cross-examine the prosecution witnesses, but on his refusal to cross-examine such witnesses, the inquiry officer himself proceeded to cross-examine the self-same witnesses, violating the principle of natural justice, which also shows his utter biasness to such proceeding, which, in considered view of this court, cannot be condoned. In view of such, the submission of Mr. Das the submission of Mr. Das, relying upon the reported decision of Ram Lakhan Sharma, bracket Sharma, that sufficient opportunity was given to the delinquent to cross-examine the prosecution witnesses, cannot, however, cure the defect as occurred in course of the inquiry proceeding. Stop there. In view of such, this court thus finds sufficient merit in the instant writ petition. Accordingly, the instant writ petition is hereby allowed. Stop. Accordingly, the respondents are directed to withdraw / revoke / cancelled and or resigned the impugned order number 272/2015 dated 30/09/2005 as passed by the respondent number 3 and the order dated 9/1/2017 as passed by the respondent number 2 with immediate effect, and thus the punishment as imposed upon the writ petitioner by these respondents herein stands hereby cancelled. With the aforementioned observation, the instant writ petition is.
The petitioner in the meantime has retired from service. So lordship of consequential benefits, including his pension, may be accordingly.
All right. It is reported.
Representation
It is submitted by Mr. Lahiri that in the meantime, the writ petitioner has retired on his
attaining the age of
on his superannuation. Such being the position, the respondents are directed to clear all his arrears of pay and retirement benefits within 6 months from the date of communication of this order. Stop. The instant writ petition is thus disposed of. Urgent zero certified.
I am deep liberal, and my lord, the right to get a fair trial by an impartial authority is now treated as human right. But that is the judgment of the Supreme Court and also other
Mr. Das, yes, that's true. Just put an endorsement authenticated by me and put your signature and date. এইটা দিতে হবে নাকি? না ওটা দিয়ে দিন।
অপোজিশনটা দিন আমাকে।
দিন না উকিল এটা।
Item 46.
আজকে 8 তারিখ 43টা আছে।
এই এক সেকেন্ড, একবার 43 ফাইলটা দিন তোমার।
27/2
Don't call, just hand over the file of 43. WPA 4640 of 2020. আছে এখানে? Just a minute, sir.
Number 43.
Don't call, just give me the, I want to see the file. ঠিক আছে, এটা আজকে ভুল করে আছে, এটা 27 লেখা আছে।
instead of 27 may it be tomorrow, my lord?
Which one?
43.
43, it has been fixed on 27.
Actually, yesterday I was engaging in another court, my lord. Adjournment was sought for. That's why it was adjourned yesterday. It may be taken up tomorrow, my lord. I have no difficulty. I'm the petitioner.
No, it will be taken up on 27 because your other side is not here.
I will intimate him by giving written notice.
If you can bring both of them,
Yes.
both you and your other side at 2 p.m, I can consider. Otherwise not.
Tomorrow, my lord,
No, sir.
27th.
That would be unfair.
No, I will serve notice that it will be taken.
Both of you are present today at 2 p.m. I can prepone the date. If you are not present, one side is present, I cannot
The
recall.
purpose of preponing the date, I can inform him.
You can request her or him to remain present at 2 p.m. and I can prepone if he or she concedes. Otherwise, I cannot.
My lord.
Otherwise, it will be taken out on 27th. এই 43 ফাইলটা একটু আলাদা করে রেখে দিন তো, দুটোর সময় যদি থাকে। নেক্সট
46.
I'm for the petitioner. Well, I also served the notice upon the respondent's advocate on the
there was a direction to that effect on 6th February.
yes,
You have not served in the meantime.
yes, I have served it.
Then
Yes, madam. This is my letter.
you want to serve again.
No, madam, I served him as per my lord's order dated 6th of this month. And this is the letter.
Yes. Mr. Prithu Dudhoria, he was appearing.
He was appearing. And madam, the affidavit in opposition under his signature.
The affidavit opposition is not filed.
No, madam,
No, it is filed. It has been filed.
opposition filed, madam.
Have you filed reply?
This is my reply. And here, it's better to argue in their presence because at the very initial stage, when this petition was admitted, my Lord Mr. Justice Justice Anindam Mukherjee was pleased to direct that the issue of territorial jurisdiction as raised by the respondents is kept open.
You want disability pension?
And disability pension. Disability pension, I met with an accident while on duty in the campus of the CRPF with arms and ammunition. And they say, no, I am not entitled because I was intoxicated. Which is an absurd story.
Where the accident occurred?
In Kerala.
Kerala.
In Kerala, the accident took place in 2003. Thereafter, I was kept in the department.
So how this court can have a territorial jurisdiction?
I'm telling my Lord. And my Lord, I was retired with pension for the years of service I rendered. And then I settled in my native place near Ranaghat. And I drew my pension as sanctioned by them from State Bank of India branch at Ranaghat. From Ranaghat, or my native place, I made a representation to them in 2019. I stated that the pension granted to me is not adequate, is not as per rules. So kindly allow me in the pension, teaching me as pension on invalidation ground. That they have rejected. Their stand is this: the pension which was sanctioned to me, that is correct, as I was not entitled to
any further pension.
Pension because the accident took place for my fault. That is not the fault of the authorities, and their allegation is this: at the time of accident, I consumed country liquor. This is their case. So, madam, I sent the representation from my native place.
If that be the case, how a read court is how the read court can adjudicate?
No, but my lord, I shall invite my lord.
Those are question of facts.
A question of fact, but my lord, the question of law will come in my respect to submission. But the section 10 of the CRPF Act provides, if any person belonging to CRPF establishment is intoxicated, is found intoxicated during duty hours, he will be punished. He shall be punished. The language is, he shall be punished. But the allegation is 2003. I remained in service with them up to 2007. When they detected that I am not fit.
And in the accident occurred on?
Accident occurred on 2003.
Even after accident, you served for 4 years?
For 4 years, and I was given a light duty, and my lord, I was under treatment, and thereafter also I was.
So at no point of time, no disciplinary proceeding was started against you?
No disciplinary proceedings was initiated against me. That is my point. That is my point.
So, Mr. Lari, what do you propose to do? You want to serve another notice?
Yes, mother, as my lord said.
Mr. Dudoria, his office, he sits at Baraswar, room number 1.
Yes.
Ashwin bhai. Mr. Lairi, learned advocate for the writ petitioner, is present. He has handed over a receipted copy of letter dated 7/2/2024 addressed to Mr. Prithu Dudhoria, learned advocate appearing for the respondents / Union of India and its officials. In spite of such service, none appears on behalf of the respondents / Union of India and its officials. Mr. Lairi files.
Sorry, my lord. Tender apology, my lord. But I'm appearing for the respondent. I have filed the opposition. In this case, Mr. Shyamal Mukherjee was engaged, senior, my lord. He has some difficulty, personal difficulty today, my lord. He prays one.
Get it up.
So,
If you remain busy, why don't you ask any of your friends to?
so, but I was suddenly when a matter was called, I tender apology, my lord. With folded hands, my lord. Tender apology, my lord. Only praying for not today.
Your good name, sir?
Prithu Dudhoria. I have filed
Mr.
opposition.
Lairi, an advocate for the petitioner, and Mr. Prithu Dudhoria,
Yes,
an advocate for the respondents / Union of India and its officials are present. The affidavit in reply as filed by the petitioner be taken on record. Stop. On behalf of the respondents, an accommodation has been sought for on account of personal inconvenience of learned counsel,
Mr. Shyamal Mukherjee.
Mr. Samuel Mukherjee, who has been assigned on behalf of the respondent to argue this case.
Yes, my lord.
Who has been assigned on behalf of the respondents to argue this case. Stop. Prayer for accommodation is considered allowed. Stop. Let the matter be listed on Monday. February 12, 2024, under the same hearing.
Grateful. Well, Tuesday, lordship. Tuesday.
Tuesday is the last day of my sitting in the single bench, which is why I am. If it cannot be taken up on any reason for 12, it can be taken on 13, which is why I want.
My lord, my lord. Well, your lordship can fix tomorrow also. Mr. Mukherjee is available tomorrow, my lord.
Tomorrow?
Tomorrow?
Tomorrow, I have no difficulty, but tomorrow is the day of civil division of my lords.
Then Monday, my lord, then your lordship fix.
Tomorrow.
Tomorrow.
Civil division, after civil division, if time permits, it will be taken up. Tomorrow.
My lord, my lord.
Tomorrow means 8th, naki?
8, yes.
No,
Tomorrow, 9.
9.
Vale. দুজনেই বসুন আপনি এখানে বসুন
Item 47.
May I please, Your Lordship, on behalf of the petitioners. The petition. Motion. Petitioners before Your Lordship were engaged in the contractual terms not in different posts under the other backward classes. Your Lordship kindly takes not the date of appointment and others kindly comes to page 20. Prayer is not for increased remuneration. As per government has taken a policy decision to issue circulars for increasing the remunerations of contractual and daily rate employees. So I'm just covered by the circulars. So I just want to get the increased circular as per increased remuneration as per the circulars. That is my simple prayer. Now let me not satisfy Your Lordship the how I am entitled to get those and what are the circulars relevant on the field. Your Lordship knows earlier in the earlier government engaged so many contractual employees in different departments, finance department, the other departments also. Those were the circulars covered the correct? But in different group C and group D.
Group C and group D
Group D.
category.
Group C and group D
The
category.
present petitioners belong to
Group C and group D. Group C and group
Both. They are contractual employees.
contractual employees.
Yes.
Now earlier the prior to coming in force of this government, the earlier the circulars were that if the concerned employee worked more than 240 days in a year and continuous for 10 years or like that, they were given some benefits, but not the permanent. Now, as a welfare state, we welcome the policy of the government. The government has taken a policy decision that to continue to engage these contractual employees, not to take away their livelihood by allowing them to continue till the age of 60 years. And up to that period, the minimum pay band scale that is allowed, subject to certain conditions, up to certain remuneration, up to the persons who have been working for 5 years and then moved 5 years to 10, 15, 10 years, 10 to 15, those slabs were there. Now, government as a welfare state taken a decision to give some benefits, at least in the dearth of employment, these poor people get something to earn their livelihood. Now, thereafter, the government.
But your appointment was purely contractual and temporary.
Yes, yes. The circulars are on the field also. The government took a policy decision to give the benefit to the contractual employees who were appointed there. Now, according to the terms of the tenure of service, those remuneration will be increased day to day, time to time, and the government had taken a decision. And sometimes remuneration increased, and thereafter the lump sum amount which is payable, it was initially 1 lakh, thereafter 2 lakhs, thereafter now government has taken 3 lakhs. So those are the policy decisions taken as a welfare statement. We welcome that. Now, but unfortunately, those contractual employees were engaged. The government although issued the circulars but not implemented the circulars on the pretext that those circulars have issued by the finance department, it is not applicable to other departments or like that. But kindly comes to the appointment of the petitioners.
Before that, I'm asking one question. Whether affidavit in opposition has been filed?
Absolutely. Everything. Affidavit opposition filed, reply filed, supplementary affidavit also filed to show discrimination, how one person.
No, I find the writ petition.
Affidavit file
affidavit in reply.
Affidavit.
But where is the affidavit in opposition?
Opposition, we have been served. Earlier,
right, sir?
This is we have been served. I've been in opposition.
No, my lord, it is with me. Actually, my lord, this is after change of panel. This is
Right.
so, my lord, before filing this affidavit in opposition, I have a preliminary objection to make. If your lordship, my lord, decides that particular thing, I'll be filing.
No, I'll decide that question along with the writ petition.
Yes, ma'am.
My lord. So, my lord, this affidavit in opposition may be kept on record. My lord,
Yes.
This is the affidavit in opposition.
Yes, sir.
The petition number 1, that he was engaged in the post of superintendent, and he comes to page 20 7. Read petition.
Page 27.
Yes, my lord, of the read petition. Your lordship will find Subhashis Das, the name of the petition number 1. Page 28, my lord. Page 27 is the appointment letter. It's dated 19/6/2018.
Just in pursuance of order number such as the backward class department and other also in this recommend we have engaged the police engaged I have engaged busy hostel develop. Page 28.
Yes, 27 is the appointment letter of the petition number 1.
Yes.
And page 28, your lordship kinds some other petitioners. I'm just without repeating, same times of appointment letters in respect of some of the petitioners. Not just I'm referring to the document issued by these respondents, page 28.
Page 28 is the annexure to page 26.
Yes, yes. Not I just in short, what I'm showing.
He was the superintendent contractual.
Subhashis Das.
Remuneration 12,000.
12,000. Then it kindly comes to serial number 2, Anirban Mondol.
Yes.
He was appointed.
Anirban Mondol is also the petitioner.
Yes, yes. Petition number 2.
Yes.
Petition number 2, appointed in the post of caretaker contractual. Remuneration is 8,000.
Yes.
Then that kindly comes to serial number 6. Different hostels in different districts. So
Kormabandhu.
Yes, Kormabandhu. Torun Kanti Pal Kormabandhu remuneration is 3,000. Now that kindly comes to the other petitioners. Page 35. Shamapti Maiti. Page 35. This is the appointment letter and the annexures next page.
Pandit Raghunath
Shamapti Maiti, matron, in the post of matron.
Where from I will get that?
That page 35 is the appointment letter, and the next page your lordship will find
is the merit list.
It's a merit list. This is Shamapti Maiti, post matron. No, matron post. Then, my lord.
Matron means nursing staff.
Yes, matron. She is actually matron in the post of matron. Now, petition number 5 is group D post is night guard, page 39. Page 39, this is the merit list. Shubhajit Bhanjo, Darwan Kam night guard, serial number 3 from the second box. And
Yes.
so these persons were appointed sometimes around 2018-19. So they have been working for more than 5 to 6 years. Now, one petitioner, petition number 6, he was appointed in 2013, page 43, 44. Page 43, 44 sufficient, 43 and 44 also. In the help post of helper to cook, remuneration is also 3,000. Page 44 will be sufficient. No? Remuneration in favor of PARTHA Pine, contractual engaged by the concerned committee to the temporary post of helper to cook at Diamond Hospital from 2013. So
PARTHA Pine is also the repetition.
But these are the admitted facts. Now, my lord, lordship kindly comes to the relevant circulars not holding in the field. Not prior to these appointments, there was one circular which that I cannot take the advantage of that circular, but I must point out to that these circulars were filled when they was appointed, when the remuneration was just much more in case of group D post also. Page 53 of the writ petition. Circular dated 25/2/2016. That I pointed out that after coming into power, this government had changed the policy and given some relief to the contractual employees. That page 25/2/2016. In this department, it was decided to allow appropriate emoluments, security of tenure and certain terminal benefits to
You
the
are
casual.
referring page number 53.
53, 20, dated 25 to 26 is circular.
Sorry?
25, circular dated 25th February 2016. The government's decision to change the policy to give the some security to the contractual employees. It was decided to allow appropriate emoluments, security of tenure and certain terminal benefits to the casual, daily rated, contractual, all three covered. Casual, daily rated, contractual workers subject to the fulfillment of conditions therein. The matter regarding improvement of monthly remuneration, annual increase, medical facility, leave and others benefits, as well as review of the conditions of engagement were under active consideration of the government for some time past. Now, after careful consideration of the matter, the government has been pleased to
I've
decide.
gone through this memorandum when I was in district judiciary.
By that, definitely.
Because in court, there are always many contractual
Absolutely,
employees.
absolutely.
So
That's
I'm
why
aware of this fact.
yeah, at the outset, when I pointed out that these are these circulars, benevolent circulars giving some respite actually. But now, after appointment, what are the circulars? ঠিক আছে, যশোর দেখেছে take tenure of 60 years, some benefits after retirement, although very small paltry sum. Now, after coming into after these appointments of the petitioners, circular number 8th February 2019.
The read petitioners were appointed from the year.
One read petitioner 2013, read petition number 6, and others 2018, some 2018 and some 2019.
So those were the read petitioner who has been appointed in 2013, he got the benefit of this memo.
No, still now he is getting 3,000 at these days, even after appointment, after serving for more than 11 years. Now that kindly comes to page 55. Circular dated 8 February 2019. Just out of the context, these circulars were issued taking consideration of the hardships of the contractual employees, but in different departments. I argued a case of the Digha Sampurkur Development Authority. Those employees have been working for more than 15 years, 20 years. Even they are not getting this benefit of this circular. This is one such example where the exploitation of labor and violation of Article 14 and 16. That kindly comes to 8 February 2019. The question of further improvement as the conditions circular, I did not read everything, but kindly see the increased remuneration. The chart in the box given. The workers who have.
Please read the first line. First two lines.
Yes, but the question
of further
improvements on conditions of service of casual, day-rated, contractual, all covered. Contractual.
According to you, the present read petitioners are covered.
Contractual. Absolutely. But contractual, not only contractual, all day-rated, casual even covered. But I'll rely on judgment also.
Yes.
Casual, day-rated, contractual workers engaged in various government establishments in terms of memo number such and such has been for active consideration of the government for some time. This is 16th September 2000, the earlier circular before coming to this government. After careful consideration of the matter, undersigned is directed by order of the governor to say that the governor has been pleased to decide as follows: with effect from 1st February 2019, the consolidated remuneration of the above categories of workers will be revised. Period of engagement less than 5 years. Existing remuneration, this is from Group B.
These are
Increased remuneration.
But
Group
how,
B,
according to you, these are applicable to you? That is to be looked into.
Yes, and not only that, clause number 3, those who have been working in Group D post, page 55. 55. That this is also important. Clause 3 from the bottom, that second paragraph. The above categories of Group D workers who possesses educational qualification of Madhyamik pass or above and have been in engagement continuously for more than 3 years will be given the benefit of engagement as contractual casual rated Group C workers from this prospective date, subject to availability of the vacancy in the Group C category. So if there are vacancy, then Group C post will be promoted to a Group D post will be promoted to Group C. So these are the relevant circulars. Another circular that kindly comes to page 59. Same kind of circular that dated 15 July 2019. some more benefits, increased remuneration. Less than 5 years, just 12,000, and then 5 to 10 years, so on, so on. Now,
Just a minute, sir. It is with regard to the employees who are working in companies, corporation, undertaking and statutory bodies, wholly or partially owned and controlled by the government of West Bengal or by anybody.
It extended to those organizations.
They will redeploy in other departments and their pay structure will be like that.
Will be this.
Yes.
And in my case, the petitioners, petition number 1, 2, and 4, they are group C, and remaining group D. 1, 2, and 4, they are group C, and others are group D.
Petition number 1 is group C.
Yes, one is group C, 2 is caretaker group C.
Just a minute.
Subject to correction.
Petition number 1,
1,
group
2,
C.
yes, is a superintendent, and 2 is caretaker. He is also group C. It says hostel, and petition number 3 is sweeper group D. Petition number 4, matron group C. Petition number 5, night guard group D. And petition number 6, helper to cook, he is also group D. So all group D staffs are getting 3,000 per month till date. And petition number 1 is getting superintendent 12,000. And petition number 3, petition number 2 and 4 are getting 8,000.
Petition number 1 is getting now
to 12,000. It was mentioned in the appointment letter and the advertisement also.
What about
petition number 2 is getting 8,000 per month till date from the initial date of appointment, same salary. Petition number 3 is 3,000. Petition number 4 is 8,000.
Yes.
Petition number 4 is 8,000. Petition number 5 is 3,500.
Petition number 5, 8,000.
3,500. He is getting, and 6 is 3,000. Those are admitted facts in the affidavit opposition documents annex. Those will suggest that.
These people are all full-time employees.
Full-time employees. One, except one is part-time, and others are full-time employees.
Who is part-time?
That part-time is
Karmabandhu.
Yes, one Karmabandhu, probably not petition number 5. Okay, jigesh korun na. Petition number 5 is part-time. 5 or 6, just clients are here, just confirming. Not kindly comes to the end, I have made several representations to the authorities. Those representations are not at page 70. In the light of these circulars. Page 70, 74, 75, and 76. All these circulars.
70,
74, 75, 76. Successive representations to relevant authorities. Paper. The part-time is only petition number 3. I'm sorry, not. I stand corrected. Part-time is petition number 3. Now, similarly circumstanced persons.
Part 70.
Yes, similarly circumstanced persons, they have been engaged on the basis of these circulars getting increased remuneration.
All the petitioners are employed in the
other backward
same department.
Other class backward classes.
Same department.
Same department in different hostels under the other backward classes. The advertisement is also there. Worship will find the advertisement. Whether kindly comes to the advertisement at page 63. Page 63.
অনগ্রসর সম্প্রদায় কল্যাণ বিভাগ. It means other backward class
classes
development
welfare department,
welfare department.
which is also annexed in the affidavit in opposition filed by my learned friend at page 8,
Very good.
dated 26 to 2016. Now, these are the admitted facts. But one more important thing, that similarly circumstanced persons under the same department have been given with the benefit of these circulars. That kindly comes to, that kindly pardon me, just this is little bit eligible. I got the from the WhatsApp, page 57. It's an order dated 14 to 2019. That in different post, matron, caretaker, matron, they have been giving, they are getting this increased remuneration as per the circulars. A circular dated with effect from 1 to 2019.
In pursuance of audit department, finance
Such and such has been pleased to accord approval to allow appropriate emoluments and other terminal benefits in terms of finance memo number such and such 69/20/22/11. That's not I referred, and subsequently modified by the 25 to 2016 that I referred in favor of 5 caretakers, 4 matrons engaged contractual basis against regular sanction post in working in different central hostels in West Bengal under such and such with effect from 1 to 2019. Now, my lord,
just a minute, sir. Yes.
that kindly comes to I have filed affirmed one supplementary affidavit, which is on record. Sub the copy also to my learned friend.
Usually the department sends the matter to the finance department for
Yes.
financial accord.
Yes, but all these
That has been communicated.
all these circulars have been issued by the
Finance department.
finance department. So those are to the followed by the other departments as well.
Absolutely.
Now they have taken a stand. Kindly comes to one document, 1 or 2 documents that will end my submissions.
What is the finding of the finance department?
Finance department has not said anything. They say that these backward classes department.
Backward class department has
not
the matter to the finance department.
No, I mean, so far my instruction on record, I do not find anything.
Okay.
That kindly comes to the stand taken, they affidavit opposition, but prior to that, just one document of the supplementary affidavit, how discrimination and violation of Article 14 also. This, I referred to one paragraph of the circular where the Group C will be promoted to, Group D will be promoted to Group D. One candidate of such has been given some benefit. He has been promoted to Group D from Group C. Kindly takes my supplementary affidavit, page 4. Supplementary affidavit affirmed on the 14th June 2022. Just very short supplementary affidavit.
Yes.
That kindly comes to page 4.
Yes.
Group C theke. That kindly comes to page 4. That second name from the bottom, Vishwajit Pine.
Vishwanath Pine.
Vishwanath Pine, I'm sorry. Post in which working DCNG Night Guard, Diamond Harbour, date of appointment 2002, Madhyamik. Then your lordship, kindly page 5, kindly comes to page 5. In pursuant to the order such and such BCWTD, dated such and such, Vishwanath Pine has joined in the post of contractual Group C worker against sanctioned vacant post for Group social worker on such and such in the office of the undersigned. Now C. Pine is here. So he is promoted from group C to group D. Group D to group C. And this is
What reason has
that
been
this-
assigned by the department?
No, I'm coming just. But this is not the final circular, department circular. Not I've referred to 8 February 2019 at page 55. This clause was there. This is followed by them. Our backward classes. Now the reason
If
department.
if he has passed Madhyamik and if there be a vacancy, he will be
Yes,
promoted.
and he has been promoted. Now kindly comes to the stand taken by the respondents, my reference client. But kindly take their affidavit in opposition. Firstly, kindly comes to page 15. Other facts are admitted. Page 15. They issued an order on 19/1/2018 initially. The increased proposal kindly comes to the entire second paragraph is also relevant because finance circulars have been followed. It had been either under active consideration of the government for some time past to enhance the remuneration of following categories of hostel staff and others under the administrative control of backward classes, welfare and tribal development department. Now, after careful consideration of the matter and in pursuance of the memo number such and such, backward class such and such, in concurrence with the such and such of the finance department. But once the finance department has issued a circular, it may not be necessary even subject to correction, but they have to follow the finance department circular. Finance department remuneration of the staff, ashram hotels, central hostels, pre-development such and such, and tried development is hereby enhanced. What is the page 15 of the affidavit in opposition? Affidavit in opposition. But this is the for ashram hotels such and such, such and such. No remuneration, no increase for B, superintendent, caretaker. Little bit remuneration for group D, 3,000 to 3,500, 3,000 to 3,500 in some cases. But in my cases, only one candidate is getting 3,500, others are not. Now, after this.
Sorry, I cannot follow. You repeat
here,
your submission.
That here, that the increase, this by this circular, they say the superintendent, the candidate working in the post of superintendent, his existing remuneration is 12,000, there will be no enhancement. If caretaker 8,000, no enhancement. But B, I'm covered by this B for central hostels. Cook 3,000, 3,500 for 50 students and 4,000 exceeding 50 students. Darwan Kam night guard 3,000 to 3,500. Sweeper such and such, such and such. Now, even this circular is also contrary to the other circulars of the finance department. Now, the final stand is taken, which will transfer from page 17 of the affidavit of opposition. But I do not find any such circular. But even then, these, if is violative of Article 14(16), then this stand cannot be accepted. This is 8th August 2019. It has come to notice of the department that some of the officers have engaged contractual designated persons with the approval of the concerned district magistrate or otherwise, and have sent the proposal for enhancement of their remuneration as per memo number such and such of the finance department. In this context, it is not my case, district magistrate, with concurrence approval, we were engaged. In this context, it may be stated that this enhancement of remuneration, other benefit is applicable only those employees redeployed by members such and such, both of finance department and not for any other workers engaged otherwise. But I do not find any substance in how this redeployment, question of redeployment comes in this field. And with the current status, once government has taken a policy decision to give the benefits of these circulars to all types of employees, contractual, there is no discrimination, no classification. Even if there is classification, that is irrational, that is arbitrary, violative of Article 14. Finance department has not said that these circulars will be given, benefit will be given only to this department, only the employees working under the finance department and no others. It's a policy decision of the government. Finance division is the final applicable authority who has given approval to the circular for giving benefits and implementation of the policy of them, and that this department, other backward classes cannot deny this benefit of this circular. Now, kindly comes
just a minute.
Mother.
2014 finance order has been enclosed with your writ petition.
No, I don't find any such.
They have enclosed.
No, they have not even, they just referred.
Yes.
Even those circulars are existing in the field. Those are absolutely not applicable. In my case here, the district magistrate concerned officers have engaged without concurrent sanction or nothing. But here it is not that. That kindly comes to my last submissions. That whatever maybe the
No,
circulars
in their affidavit in opposition,
they state this.
what reason they have assigned?
There's reason that this circular we are not redeployed. That's why the benefit of this circular. We have accepted this contractual appointment. That is
in which part of the affidavit?
Mother kindly comes. Yes, Mother kindly comes to this Mother page 5, paragraph 5, page 2.
Page 2.
They rely on the appointment terms. That this is the conditions which you have accepted. You cannot go beyond that. With regard to statement made in paragraph 4 of the said writ petition, I deny dispute. I say that appointment of petitioners are purely contractual. An appointment letters clearly indicated the terms and conditions. Engagement is made purely on contractual basis. No financial benefit except the amount of remuneration as mentioned be admissible. So once I accept the appointment,
So read the next
all other terms of contractual appointment in government West Bengal will be applicable in this case also. This also covers my case. If the government takes some policy decision to revise the policy to give some benefits to contractual appointment, then this should also apply. So this goes in my favor. And I say that as per order of the special secretary such and such, the hostel staff such and such are engaged only on purely contractual basis. And in case of hostel staff such as per order of such and such, on purely part-time, temporary, tough time. I say that the engagement remains beyond the purview of the other notification circular memo of the finance department, such as finance department to his 2016 and subsequent memo, only the memo of the respective departments such as BCW department.
You are reading which portion?
Not paragraph 2 I was reading, paragraph 5 from page 2, last paragraph, last sentence, thereafter page 3 and page 4. Page 3 not the relevant portion.
I say, further say.
I say that as per, yes, I further say that engagement remains beyond the purview of the order, notification, circular or memo of the finance department. As such, finance department memo number dated 25/2/2016 and any subsequent memo, only the memo of the respective departments such as BCW departments and tribal departments memo will be applicable. With regard to the statements I made in paragraph such and such.
No, just a minute, what does it mean?
It doesn't mean say that only the finance department's memo we cannot get the benefit of the finance department memo unless BCW, backward classes welfare departments issue a separate memo. That's the stand. They say we are governed by this department is governed by the circular issued by this department only. So finance department memo will not be applicable to this department. That is this. Which my respect to submission will not absolutely unsustainable. Because parent department giving approval sanction is finance department.
So far my knowledge goes, when a question of financial implication arises,
accord, sanction.
Financial accord
Absolutely
is necessary.
In which finance has issued. Finance is issued that circular. Once the finance issued that circular 2016-19,
right.
it will be applicable to all.
Let me hear him.
It's just one thing.
Just a minute.
Just one thing. One landmark judgment, your lordship has come across this judgment that where the Honorable Supreme Court, based on this directive of principles for state policy, that have considered all these aspects, this temporary, contractual, daily rate workers, if they work, like the nature of duty, same that they are to be given this benefit of the equal to the regular phase. I'm not even that. My case stands on the stronger footing. I'm just claiming the benefits remuneration which given by the circulars. But my right goes even beyond that. I am entitled to get the regular pay scale of the regular employees. I am not that. that the Supreme Court had taken this, these all these points and they considered this judgment. But I just
What
point out
Supreme
this.
Court has said?
The 2017 1 SCC page 148.
2017
1 SCC page 148. State of Punjab and
volume 1 SCC page
148.
148.
These the different aspects came into consideration.
Para?
Paragraph 26.2 at page 190. Paragraph 42 at page 205. Paragraph 43, 209. And finally, after considering all these decisions, the dissenting decisions also had taken consideration. Paragraph 46.2 and 46.3. And then lastly, paragraph 46.10. There, Supreme Court said, the state cannot exploit this poor contractual employees on these grounds, even on the grounds of mode of selection, other things. Even that if the state takes a stand that these were not sanctioned posts.
What is the finding of the Honorable Supreme Court with regard to
temporary employees?
Equal work and equal for equal pay.
They granted this. They had to be given. Supreme Court said that they had to be given the benefit of this pay scale if the nature of duties are found to be similar like that of the regular employees and if they work in the perennial nature continuous. Now, that is the well-marked judgment. And following this judgment, our court, Justice Moshumi Chatterjee also passed order. This is the photocopy I have the judgment. Moshumi Bhattacharya, sir. Part-time teacher there. May I just read, if your lordship permit me to. That kindly comes to page, paragraph 26.2 first, at page 190. This court held that, as your lordship got it, that it was not open to the government to exploit citizens, especially when India was a welfare state, committed to a socialist pattern of society. The argument raised by the government was found to be violative of the mandate of equality enshrined in Article 14 of the Constitution. This court held that the mandate of Article 14 ensured that there would be equality before law and equal protection of the law. It was inferred therefrom that there must be equal pay for equal work. Having found that the employees engaged by different Nehru Yuvak Kendras in the country were performing similar duties as regular class 4 employees in its employment, it was held that they must get the same salary and conditions of service as regular class 4 employees, and that it made no difference whether they were appointed on sanctioned posts or not. Sometimes states takes that stand, that's why. So long as they are performing the same duties, they must receive the same salary. Then lordship kindly comes to page 205. Other discussions, other decisions are there, which came into consideration before their lordships, but kindly comes to page 205. Considerations, Lord. Last paragraph, paragraph 42. As your lordship. All the judgments noticed in paragraph 7 to 24 herein above pertain to employees engaged on regular basis who are claiming higher wages under the principle of equal pay for equal work. The claim raised by such employees was premised on the ground that the duties and responsibilities rendered by them were against the same post for which a higher pay scale was being allowed in other government departments. Or alternatively, their duties and responsibilities were the same as of the other posts with different designations, but they were placed in a lower scale. Having been painstakingly taken through the parameters laid down by this court wherein the principle of equal pay for equal work was invoked, and considered it would be just and appropriate to delineate the parameters laid down by this court. In recording the state parameters, we have also adverted to some other judgments pertaining to temporary employees, also dealt with in the instant judgment, wherein also this court had occasion to express the legal position with reference to the principle of equal pay for equal work. Our consideration has led us to the following deductions. The onus of proof of parity in the duties and responsibilities of the subject post with reference to post under principle for equal pay for equal work lies on the person who claims it. He who approaches the court has to establish that the subject post occupied by him requires him to discharge equal work of duties as reference post such and such. The mere fact that the subject post occupied by the claimant is in a different department vis-a-vis the reference post does not have any bearing on the determination of the claim under the principle of equal pay for equal work. Persons discharging identical duties cannot be treated differently in matter of their pay merely because they belong to different departments of the government. The principle of equal pay for equal work applies to cases of unequal scales of pay based on no classification or irrational classification. For equal pay, the employees concerned with whom equation is sought should be performing work which, besides being functionally equal, should be of the same quality and sensitivity. Persons holding the same rank designation in different departments having dissimilar powers, duties, responsibilities can be placed in different scales of pay, cannot claim the benefit of principle for equal pay of equal work. Such as, therefore, the principle would not be automatically invoked merely because the subject and reference post have the same nomenclature. In determining the quality of different functions and responsibilities under the principle for equal pay for equal work, it is necessary to keep in mind that the duties of the two posts should be equal sensitive and also qualitatively similar. Differentiation of pay scales for posts with difference in degree of responsibility, reliability, and confidentiality would fall within the realm of valid classification, and therefore pay differentiation would be legitimate and permissible. The nature of the work of the subject post should be
So according to you, the present writ petitioners falls under the category of the same employees in respect of whom the finance department has issued those two circulars.
I'm not even claiming the pay scale of the regular employees. I'm just claiming that minimum pay band which is the finance department has.
Let us see what he says. Yes, sir. It's better. No issue. I will ignore that. এটা ফেরত দিয়ে দাও। Yes, sir.
My lord, may I? No, my lord, whatever has been stated in the affidavit in opposition, I believe that your lordship will be unison with me that I am entitled to argue any law point irrespective of any amendment made in the affidavit in opposition. My
law point
now,
is
my lord,
always-
admitted fact is this: there are 6 writ petitioners. 6. Now, my lord, the petitioner number 1, 2, and 4, according to the writ petitioner, they are working in Group C in different organization in different nomenclature. 3, 5, and 6, maybe they are under backward class welfare department. 3, 5, and 6, they are under Group D. Working in a different post, different nomenclature, they are getting different scale of pay. My lord, I don't understand, subject to correction, how, what is the jural relationship and how they can agitate their cause in a single writ petition by way of paying only one court fee. My lord, they cannot join in a single writ petition since it is an admitted fact that 1, 2, and 4 is Group C in a different nomenclature. 3, 5, and 6 is a Group D employee. They cannot join in a single writ petition.
Sorry for pausing, Lord.
Maybe.
If these are technical points, but I undertake to
But there
punish
is
the
no
court fees even
question of
today.
technicality. My lord, somebody
No,
is
if
working
this
in a
is-
Group C post, somebody is
irregular-
working in a Group D post, my lord, subject to correction, they cannot join in a single writ petition. That is my understanding. Now, my lord, be that as it may, what is the case of the writ petitioner? Lordship kindly takes up the statement made in paragraph 10 of the writ petition. Paragraph 10, page 15 and 16 of the writ petition. My lord, may I be permitted?
Para 10.
Para 10 of the writ petition. That your petitioner state that the authority concerned for non-payment of the remuneration of the petitioner who are working about 240 days per year and they working about 10 years, but the authority concerned are not considering the application of the petitioners. They are not allow the petitioners to receive the proper remuneration. My lord, pausing here for a moment, it is the admitted case of the writ petitioner that save and except petitioner number 5, all other writ petitions, they are engaged from the year 2018. Now, my lord, how they are entitled to make this averment? that they are working for a period of 10 years? On the face of this writ petition should be dismissed. They have made an averment that we are working for 10 years. Their case is that we have joined in the year 2018. So we are in 2024. Writ petition was filed in the year 2021. Now, my lord, somebody joined in the year 2018, filing writ petition in the year 2021 is making averment in the writ petition that we are working for 10 years or more than 10 years. My lord, this is unheard of. Now, my lord, kindly cease the prayer. A writ or orders and directions in the nature of mandamus directing the respondents, their agents, subordinates to consider the representation of the petitioners regarding their salary remuneration as a contractual workers in terms of notification annexure P2 and P4, and also not to disturb the personal peaceful works of the petitioners, and also to pay the arrear remuneration from the date of appointments and date of notification to the petitioners. Now, my lord, pausing here, lordship kindly takes up the annexure P2. That is the mother notification. And all subsequent notifications, those are not even corrigendum, but addendum to annexure P2. My lord, kindly seize annexure P2. What is annexure P2? Page 46 of the writ petition. Now, my lord, may I place this, my lord? In order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual, daily rated, lordship has got it, my lord, contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years. The petitioners, again, my lord, pausing here for a moment, there is no locus. They have their cases, they are engaged in the contractual service only in the year of 2018, my lord, save and except one writ petitioner. Now, my lord, I am reading the other paragraphs. In 10 years, in connection with implementation of various schemes, projects, various department, government, 2 departments, such and such, my lord, some references given to some memo were issued by the government in finance department. Now, the question of making the provisions of 2 aforesaid orders.
Just a minute. Just a minute.
My lord.
So according to you, the present petitioners are not appointed
in the zone of
for 10 years.
No, but it is their case, admitted case, that we have joined in the year 2018. Lordship kindly sees they have
appointment letter.
Yes, 2018. There is no locus. They have made averment in the lordship has seen, lordship has understood, my lord. This is my respectful submission. I will not linger my submission. Again, my lord, at the cost of repetition, this writ petition is not maintainable. At the instance of 6 writ petitioners joined in a single writ petition, working under different nomenclature, different organization, maybe. And second, because of their own admission on oath that, my lord, we have been appointed in the year 2018.
To you,
my lord,
the finance department parent.
This is
only 2011.
Yes.
And subsequently, those are revised.
Those are addendums. My lord, those are addendum. But this is the mother circular. This, my lord, the other circulars.
They, according to, they do not come under the consideration zone of 10 years.
Yes, my lord, not according. It is their admission that they say we have been appointed in the year 2018.
No, it is your contention.
Yes, this is also my contention based on their document that they are not under the category. My lord, there is no locus for them.
Very good.
My lord, this is my respectful submission.
This much.
My lord, this much.
Very short reply, my lord.
What have you got to say with regard to that?
May I have your lordship's kind leave, my lord, my learned junior?
Just a minute. I'm sorry. I forgot your name.
My lord, Rajoshi Basu.
Rajoshi Basu.
Yes.
Very short reply. At the outset, I said that the earlier government took a decision in 2011 and like that.
No, just
Yes, I'm
answer to
coming.
that question.
Yes, yes, yes.
How you
This
come
is-
under the consideration?
Yes, yes. This circular was issued considering the field to give the benefits who were working for 10 years and more. 10 years and more. In 2011. Thereafter, when 2016 circular, this circular was under active consideration. Page 53. Page 53. But I say this circular, if you read this circular, Lordship, be kind enough to read this page 53 circular, 55 circular, first paragraph. In this department number such and such, dated 16/9/2011, that circular, my friend referred to. It was decided to allow appropriate available security terms, certain benefits to the casual designated contractual subject to fulfillment of conditions therein. Those conditions were 10 years and more. Now, this matter regarding improvement was considered and fresh conditions given that this chart less than 5 years who were working, even those cases employees remuneration was increased. So that condition is relaxed by issuing this circular itself. The candidates who were holding the post less than 5 years, 5 to 10 years, even both these categories, Group D, Group C post. So those rigorous conditions of 10 years, that has been relaxed. That's taken by the policy decision by the government. Not only this one, also page 55. Page 55, my lord. And that's why, my lord, the next page is also given, page 54. The government has been PARTHA pleased to decide a high power committee will be formed to review the conditions. And this will take effect from 1st of March 2016. So that circular gone. Rigorous conditions of those circulars have been relaxed by issuing these circulars. Otherwise, giving the benefit to candidates working less than 10 years from 5 to 10, that could not have been brought under consideration. That would have been redundant. And then same kind of circular, page 55 also. Page 55, in the first paragraph, this 2011 circular has been considered. And even then, the conditions not here, even less than 5 years. In those cases also. 53, 53, first column is less than 5 years. 55 also, first column is less than 5 years. So by their impliedly, those rigorous conditions of those circulars have been gone away by issuing these circulars. And that's why similarly candidates have been given these benefits, which I placed with you.
Tell me one thing. So far petition number 1 is concerned.
Yes.
Since when he is working?
In paragraph 2, I have stated, paragraph 2 of the writ petition. Dates of all these petitions.
Paragraph 2.
Petition number 1 is appointed on 21/6/2018.
Petition number
2 is 21/6 same date.
Petition number 1,
2 21/6/2018.
16.
No documents not I have
21/6/18.
18. And then petition number 2 21/6/2018.
Petition number 2, just a minute, 21/6/18.
Torun Kanti Pal also.
Petition number 3,
22/6/2018. Petition number 4 7/6/2019.
number 5,
5/1/8/2019 and 6/1/1/2013. So even the candidates who are working less than 5 years, their remuneration is also increased. And this is taken effect from 16, these circulars. So a person appointed in 2017, 18 and onwards, those will be governed by this circular, not 2011 circular. And regarding the court fees,
according to you, 2011 circular,
yes,
more specifically with regard to the coverage, period of coverage has been relaxed by the subsequent
circulars. And regarding court fees, this is my fault, my clerk, I undertake to pay the deficit court fees even by course of day. This is irregularity which can be cured, this defect. হ্যাঁ কোর্ট ফিসটা আজকে দিতে পারবে তো? That even today they are getting this much of salary when the minimum wages is more than 4,400 per day. And in the Supreme Court, in that judgment, deprecated this practice of denying the giving the minimum wages even to these workers. Huh? Yes. 100 rupees per day in some cases. Being a state, Article 12, these exploitation cannot be allowed to continue. And on the basis of these technical pleas, I maybe excuse those technical defect.
Can't say the 10 years.
Yes.
That is a 3 years.
Thereafter, subsequently, they are extending the benefit to those employees. That 11 circular of earlier government, that regime has gone. Now the new government has taken a new policy decision as a welfare state. At least to give some respite to these employees. Poor employees getting 3,000 per 500 per month, 8,000 per month at these days of that complete hardship. Minimum wages is 4,500 Calcutta. 10 years, so that has gone by the next. And discrimination is hit large. Same department. Page 57, same department is given the higher benefits. Considering this circular.
Two things I am just indicating, my lord. Page 53, my lord. Only in law points, my lord. It is not in supersession of the earlier memo, my lord. So one point
That Mr. Basu has said.
My lord, I was not there, my lord. So just I am indicating, my lord.
You are Mr. Dhar.
Yes, ma'am.
You are Mr. Dhar.
Yes.
Both the writ petitioners and the respondents, state and its officials, are represented by their respective learned advocates. The affidavit in opposition.
May I take your lordship's kind leave?
Yes. The affidavit in opposition as filed on behalf of the respondent state is taken on record. By filing the instant writ petition under Article 226 of the Constitution of India, the writ petitioners have prayed for an order for fixation of their salary / remuneration in terms of the notification number 1107-F within bracket P dated 25/2/2016 and 1033-F within bracket P2 dated 8/2/2019 as issued by Finance within bracket Audit Department, Government of West Bengal. In support of the instant writ petition Mr. Dhar, learned advocate for the writ petitioner at the very outset, submits before this court that the present writ petitioners have been employed either in Group C or in Group D post in other backward class welfare department, within bracket লেখা রাখো insert OBCW department. Stop. According to Mr. Dhar, the writ petitioner is getting salary of rupees 12,000 per month, per month. Petitioner number 2 is getting salary of rupees 8,000 per month. Petitioner number 3 is getting salary of rupees 3,000 per month. Petitioner number 4 is getting salary of rupees 8,000 per month. Petitioner number 5 is getting salary of rupees 8,500 per month, and petitioner number 6 is getting salary of rupees 3,000 per month as contractual employees. আচ্ছা একটা কথা একটু লিখে just add one thing. Petitioner number 1 আগে চলে আসুন, please come to petitioner number 1 being a group C employee is getting salary বলেছি না? Petitioner number 1 being a group C contract, being a group C employee. Petitioner number 2 is being a group C employee. Petitioner number 3 being a group D employee. Petitioner number 4 being a group C employee. Petitioner number 5 being a group D employee. And petitioner number 6 group D employee. Petitioner number 6 being a group D employee are getting at stop. Last line টা কি পড়েছি একদম? As contractual employees.
Group D, one Group D employee was promoted to the Group C.
Sorry?
One Group D employee was promoted to Group C.
No, আমাদের
Yes, there's another one.
No, my lord, only petition number 5 is 3,500, not 8,500.
3,500.
3,500.
কত লিখেছো?
Oh, no, 800.
Petitioner number 1 is 12,000.
Petition number 5, my lord.
Petitioner number 2 is 8,000.
8,000.
Petitioner number 3, 3,000.
3,000.
Petitioner number 4, 8,000. Petition number 5, 3,500,
3,500.
3,500, and petition number 6, 3,000.
Yes, my lord. Yes, sir.
Stop. Drawing attention to annexure P2 at page 46, being Government of West Bengal Finance Department memo number 9008-F within bracket P dated 16/9/2011, comma, notification number 1107-F within bracket P dated 25/2/2016, and notification number 1033-F within bracket P2 dated 8/2/2019. It is contended by Mr. Dhar that though the respondent state has duly considered the emoluments and benefits of the contractual employees are meager, and thus issued the aforesaid 3 notifications time to time to revise the benefits for extending the same to the casual/daily rated/contractual workers who are working in different departments of the respondent state, comma, for the reason based known to the respondents herein, such benefits have not been extended to the such financial benefits have not been extended in the case of the petitioners, in spite of making several representations. It is further contended that the similarly circumstanced contractual employees in other departments, even in OBCW department, have also been extended the benefits of the said 3 notifications. It is submitted on behalf of the writ petitioner that the aforesaid action on the part of the respondent state violates the principle of equal pay for equal work. Principle of double inverted comma equal pay for equal pay work, which is guaranteed under Article 14 of the Constitution of India and which has been affirmed by the Honorable Apex Court in a catena of judgments. Stop. In course of his submission, Mr. Dhar places his reliance upon the reported decision of State of Punjab and others versus Jagjit Singh and others, reported in 2017 1 SCC 148. Mr. Dhar thus submits there is a fit case for allowing the instant writ petition, directing the respondents to pay the increased salary, including the arrear salary, as per their notification dated 25 to 2016 and 8 to 2009. Stop that. Per contra, Mr. Basu, learned advocate for the respondent state, at the very outset, submits before this court that since the writ petitioners are working in different posts and in different office, they cannot join to ventilate their grievance by filing a single writ petition in absence of any joinder of cause of action and oblique or similarity of the stand of the present writ petitioners. It is further argued that even inadequate court fees have been paid by the present writ petitioners in this writ petition. It is further submitted by Mr. Basu that from the averments as made in the writ petition, it reveals that just a minute. What is it? That from the annexures to the writ petition, it would reveal that the period of employment as contractual basis of the present writ petitioners are less than 10 years, even then, in the writ petition, they have stated that they have rendered 10 years of service, which is contrary to the truth, and for which, and for such willful wrong statement, the present writ petitioner is not entitled to any relief, even any equitable relief. In course of his argument, Mr. Basu also places his reliance upon the notification number 9008-F within bracket P dated 16/9/2011 as issued by the Finance Department. It is argued by Mr. Basu that from the very first paragraph of the said notification, it would reveal that the respondent state, while issuing the said notification for modification of the emoluments of the contractual / daily rated employees, have considered those employees who can come under the zone of consideration under the said notification who have worked for a considerable period of more than 10 years. According to Mr. Basu, the classification as made by the respondent state cannot be termed as a unreasonable classification because the same is not creating a class among classes, amongst classes. Stop. It is further contended by Mr. Basu that on perusal of the subsequent notifications dated 25/2/2016 and 8/2/2019, it would reveal that those two subsequent notifications are mere addendum to the previous notification dated 16/9/2011, and those have been issued by the respondent state considering escalation of price and the financial need of the contractual / daily rated employees. It is further argued by Mr. Basu that under no stretch of imagination it can be said that the subsequent two notifications have an superseding effect over the notification dated 16/9/2011. It is thus argued by Mr. Basu that since the present writ petitioners tenure of work are less than the period as mentioned in the memorandum dated 16/9/2011, they cannot claim any benefit of they cannot claim any further financial benefit, at least at present, on the basis of the subsequent to notification dated 25/2016 and 8/2019. Mr. Basudas appears before this court. There is a fit case for effective. It is a fit case for dismissal of the instant writ petition. Stop para. This court has perused the entire materials as placed before this court. This court has given its anxious consideration over the submissions of the learned advocates for the contending parties. It is undisputed that the present writ petitioners have been appointed in OBCW department as contractual employees, and their emoluments / salary have been mentioned in their letter of appointment, which have been annexed with the writ petition. Stop. Admittedly, the present writ petitioners have been appointed in different posts, even in different categories, and prima facie, it appears to this court that they cannot stand in a common platform to ventilate their grievance by filing a single writ petition. However, considering the fact that the present writ petitioners are working in the same department, that is such and such department, OBCW department, and considering the fact that the nature of grievance ventilated by the present writ petitioners are more or less same and oblique or are of common nature, this court permits, this court in exercise of its plenary power permits the writ petitioners to ventilate their grievance by filing a common writ petition, which they have done. However, they are to file the requisite court fees in this writ petition independently, irrespective of the fate of the instant writ petition. Stop. In order to come to a logical conclusion as to whether একটু ফ্যানটা চালাতে বলতো এদিকের ফ্যানটা, in order to come to a logical conclusion as to whether the benefits of the notification dated 25/2/2016 And eight to 2019. Where I have started? In order to this fan. In order to come to a logical conclusion, can be extended to the present writ petitioners. This court proposes to look to the first paragraph of the memorandum dated 16/9/2011 as published by Finance Department of the Government of West Bengal. And the same is quoted herein below in verbatim. Stop. এটাকে set out করবে. Page number 46 of the writ petition. On perusal of the aforesaid relevant portion of the memorandum as issued by the respondent state, it reveals to this court that the respondent state has had an intention to provide security of tenure, appropriate emoluments and some terminal benefits to the casual/delegated/contractual workers who have worked for a considerable length of more than 10 years. Stop. Admittedly, the petitioners before this court have worked not more than 10 years. At this juncture, continuation. If we look to the subsequent to notifications dated 25 to 2016 and 8 to 2019, it reveals to this court that the respondent state, while issuing such notification, has again considered the eligibility of entitlement of the appropriate emoluments, security of tenure and certain terminal benefits to the casual/delegated/contractual workers who are working in different departments of the state and categorized the said employees on the basis of categorize the said employees in different tables on the basis of their period of engagement. Such as less than 5 years, 5 to 2 টা লিখবে না, হাইফেন দাও, 5-10 years, 10-15 years, 15-20 years, and more than 20 years. It thus appears, Paradigm. On comparative study of the aforesaid three notifications, as discussed supra, it thus appears that while issuing the subsequent two notifications dated 25 to 2016 and 8 to 2019, the state authority has also considered the case of the casual / daily rated / contractual workers who had worked less than 10 years, that is, those employees have been categorized under the two tables, namely single inverted comma, less than 5 years and 5-10 years. In view of such categorization, in considered view of this court, the ceiling of 10 years as fixed by the respondent state by its notification dated 16/9/2011 had given a goodbye. Stop. In view of the discussion, this court thus holds that the notification number 9008-AP dated 16/9/2011 has practically lost its significance in respect of those contractual / daily rated / casual employees who have worked for less than 5 years, less than 10 years. Stop there. Sufficient materials have been placed before this court that the present writ petitioners are working in the aforesaid department for an emolument / emoluments which is far below the emoluments as fixed in the subsequent notification dated 25 to 2016 and 8 to 2019, and it has been placed before this court that there similarly circumstanced employees in other departments have also given effect departments are receiving such benefits, and the said departments have also issued the relevant GO in concurrence with the finance department of the government of West Bengal.
My lord, may I be permitted to intervene for a moment?
Not now. Wait.
My lord.
This court thus finds that the notification dated 25 to 2016 and notification dated 8 to 2019. Just a minute. Yes, Mr. Basu, what do you want to say?
My lord, only one thing. My lord, your lordship has, my lord, hold that the other departments has already, my lord, granted this benefit to similarly circumstanced employees, and the writ petition has annexed that. My lord, page 57 of the writ petition, have a look.
Yes.
My lord, the date of, though it's, my lord, to some extent not legible, but my lord, be that as it may, what I find from serial number 1, Aparna Dash, date of engagement 2007. And this circular was issued on 14th of February 2019. So after completion of 12 years of service. In respect of
very good, very good, very good.
my lord.
That portion I will delete.
My lord.
If
And
you-
only one thing, my lord, I will not interrupt any further. My lord, the memo which I have relied on, that is 16 September 2011 at page 46. My lord, kindly sees page 47 of that particular memo, clause 10.
Yes.
The provisions of this order will not be applicable where contractual engagement has been made without any sanction post. So, my lord, the writ petitioners have to satisfy your lordship along with, to my understanding, 10 years of service, that they have been engaged in a substantive sanction post. My lord.
That I'll
My
consider.
lord.
আচ্ছা ওই পোর্শনটাই বাদ দেবো। আচ্ছা ঠিক আছে, লাইট কি আছে? আরেকটা আগে থেকে। হুম। কি? কি হচ্ছে? কি হচ্ছে আমাকে বলুন। এই তো স্যাংশন।
ওদের অপোজিশন করেছে।
করে এলো না?
স্যাংশন পোস্ট নট
Post is sanctioned. Post is sanctioned. Post is sanctioned.
At this juncture, we may
অপোজিশন
safely rely to the judgment of at this juncture, Paradip, at this juncture, this court may safely rely upon the reported decision of Jagjit Singh Supra, wherein the Honorable Apex Court, while upholding the principle of equal pay for equal work, express the following view. Paragraph 42.42 to TO2 to 42.5. Stop. Keeping in mind the proposition of law as enunciated in the decision of Jagjit Singh Supra, this court finds that there cannot be any justification on the part of the respondent state to deprive the present writ petitioners from the beneficial effect of the notification number 1107-F within bracket P dated 25 to 2016 and 1033-F within bracket P2 dated 8 to 2019 as issued by the Finance Audit Department, Government of West Bengal. Stop. Accordingly, the instant writ petition is allowed. Stop. The respondent state who is your DDO?
This one number 4 is the commissioner.
He is your DDO.
No, DDO. He is the head of the department.
All right. Respondent number 4. Respondent number 4. In concurrence with the
সাপ্লিমেন্টারি এই ওদের অপোজিশনটা কিন্তু অপোজিশনটা
respondent number 3 is hereby directed to implement the benefit of the aforesaid two notifications that number such and such, dated such and such and such and such, in respect of the present petitioners from the date of the publication of the aforesaid two notifications
and or some engagement, whichever is engagement is after that.
and oblique or from the date of their engagement, whichever is earlier. No, whichever is
Later.
the latter. Whichever is latter. কি বললাম ওর দুটো?
বলে দিয়েছে এই কমিশনার এখন পোস্ট আছে ঠিক আছে
Whichever is latter,
ঠিক আছে করেছি
preferably within 3 months from the date of communication of this order.
পিটিশন করতে পারবে
Respondent number 4, in concurrence with the respondent number 3, is further directed to pay the arrear salary and oblique or emoluments of the present date petitioners also within the set period of 6 months from the date of communication of this order. Stop. Liberty is given to the present date petitioner to file the deficit court fees on this writ petition within a week from the day of passing of this order, failing which this order will not take effect. With the aforementioned observation, the instant writ petition is disposed of. Urgent Xerox.
But only one thing I have made submissions, Lordship, kindly note that they have not been appointed in respect of any substantive sanction post and all of them. But these submissions I have made.
Mr. Basu, your submission now, Mr. Basu further contended that the case of the present petitioner is distinguishable from the entitlement of the contractual oblique delegated oblique casual employees, since the present petitioners have not been appointed in the OBCW department against the sanction post, which has been disputed by Mr. Dhar,
relying on the page 10 of the original opposition. It is there.
relying on page 10 of the opposition.
One more instance.
No more inlanges, sir. You have got the entire list.
Another circular, latest circular that is brought, July 2019, page 55. Just that circular here.
That circular?
That in your Lordship's order, your Lordship mentioned February 2019, but latest circular is July 2019. 15 July, page 59. That circular we also do. So, now touch for it.
16,
Page 59.
55.
59. You have referred to page 55. 59 is the latest. Latest circular.
59. What is that?
Number 3998 if P2 of this circular number may be again.
No, this will not be. This is in case of redeployment. I will not count. Court will resume at 2:30.
Mine.
Grateful.
Court will resume at 2:40. আজকে 2 PM তো হলো না? আইটেম নাম্বার 40 2 PM হয়েছে। তো আসেনি কেউ। আইটেম না কল আইটেম নাম্বার 40 40
Item 40.
Lord, I appear for the petitioner.
who is your other side, sir?
Mr. Dayasanko Misro is the senior counsel and Mr. Ghosh appearing as junior counsel. My lord, he was here. Mr. Junior counsel was here.
He will do the case. Your adversary will do the case, no?
He should do this, madam.
No, it was told that I'm told rather I'm requested to keep it at 2 PM.
My lord, yes, I requested and he was here. He was waiting for, and then my lord, my lord, this matter, my lord, arising out of my lord dismissal.
CRPF employee has been dismissed.
CRPF employee, my lord. He was a constable. He was dismissed, my lord. And subsequently, the constable, my lord, as of now, my lord, he has died also, my lord. So then my lord, the widow, my lord, of this constable has come before your lordship for the wrongful termination of his service, my lord.
So that she can get the
Yes,
pensionary benefits and other
absolutely.
pecuniary benefits.
My lord, that is the case, my lord. So here, my lord.
So initially the writ petition was filed by the incumbent or the present petitioner.
Present petitioner, widow of the widow has been filed. Widow has been filed.
Can widow file such application?
Widow, my lord, as the my lord, the wife of the my
Because
lord.
the legality and validity of the disciplinary proceeding and the validity of the quantum of punishment that the widow can challenge.
Documents, my lord, everything on documents, my lord. So, my lord,
I'm talking about the locus standi. The writ petitioner, the incumbent, that is who has been dismissed or who has been punished in his lifetime, he has not challenged the order of punishment.
My lord, after dismissal, my lord, that then my lord, he was killed by the my lord, that miscreants, my lord, and then my lord, the wife, my lord, of this constable has.
What is the date of dismissal?
Date of dismissal, my lord.
I'm led by Mr. D.N. Mishra, my lord. He could not, he's over 85 years old and he's not well. I'm under instruction that the matter may be taken up after 17th, but I leave it to your lordship, whatever my lord deems fit. Today I am not even with the brief. Although I've been briefed recently, I don't.
Why you have requested me to keep it at 2 PM?
I was not there, my lord.
Who was there? It is as per your request was kept at 2 PM.
My lord, I informed, my lord, my learned friend, I informed that matter will be taken up 2 PM.
Then it's all right. I'm making it not today. Please come ready on that day with the locus standi of the locus standi of the present petitioner with regard to the filing of the instant writ petition.
Milord. And
At least I am not sure of it.
I will, so taking it up next week.
Which date will be convenient for you, sir?
My lord fixes it. My instruction is 17, but I leave it to my lord.
Acha. Legun. Both the writ petitioner and the respondent Union of India are represented by their respective learned advocates. As per request made by the learned advocate for the respondent Union of India, the matter is adjourned today. Let the matter be listed on if I fix it on 13th, would it be possible?
13th, my senior will not be, may not recover. That is the only thing. Right?
February 27, 2024, under the same heading.
Milord.
It is made clear that on the adjourned date or on any subsequent date, no adjournment, no prayer for adjournment will be considered on any ground whatsoever.
Milord, can it be fixed at 2 p.m., Milord?
At 2 p.m. At 2 p.m. Correct. Please come ready with the appropriate
Milord.
law or decision, whatever will be with regard to the
Commandant order is, Milord, in this April 2013.
Very good. Yes. Any other 2 p.m. matter? Item number 1.
Item number 1.
Item number 1. I shall fix another date. I shall fix another date. It will jai, sir. Monday or Tuesday. Monday. Monday the usually result in the second
half, Your Lordship. Second half.
Find the representative. List this matter on February 12, 2024 at 2 p.m. Under the same heading and in the same position.
Very well.
What happened? Some judgments are to be delivered by me in the meantime. So I don't want to pardon myself. Very often.
Much.
Item number 59.
49.
59.
2 p.m. 2 p.m.
59.
Your Lordship, in this matter, Mr. Bhaskar Prasad Boishu and Pinaki Bhattacharya appearing behalf of the DPSC not 24 Parthha. They are busy in the courtroom number 24, Your Lordship. If Your Lordship he started, I will proceed the matter.
Let me see.
পরেরটাই আমাদের
Initially, the instant writ petition was filed by an advocate, by your advocate.
Yes, Lordship.
Subsequently, you decided to argue in person.
Yes, Lordship.
Are you in a position to argue
Yes, Lordship.
in English or in Bengali?
Bengali.
Bengali. Very good. আপনি বাংলায় বলতে পারেন মানে আপনার কোনো অ্যাসিস্ট্যান্স দরকার নেই তো
না
লিগ্যাল অ্যাসিস্ট্যান্স আপনার দরকার নেই
না এখন দরকার নেই আপাতত
ভেরি গুড ওয়েট ফর সাম টাইম একটু অপেক্ষা করুন You have filed your affidavit in opposition?
Yes, Your Lordship. Which was affirmed,
It is in the file?
yes, Your
Yes,
Lordship,
it is affidavit in opposition.
which is affirmed in day of November 2022.
আপনি কোনো affidavit in reply দিয়েছেন?
Yes,
Yes, they
Lordship.
have filed affidavit in reply.
What is that?
I have submitted on
Just a minute.
20.
Yes, I got it. Affidavit in reply is here. Yes, make your submission.
My lord, a read petition 2009 primary teachers recruitment North 24 Parganas নিয়ে এই রিট পিটিশনে মেন 4টে অ্যালিগেশন রয়েছে।
যেমন
ফার্স্ট ইনএলিজিবল ক্যান্ডিডেটদেরকে মেরিট লিস্টে ইনক্লুড করা হয়েছে। সেকেন্ড মার্কস ম্যানিপুলেশন রিটেন টেস্ট এবং ইন্টারভিউতে। থার্ড রিজার্ভেশন পলিসি ভায়োলেশন হয়েছে। আর ফোর্থ লার্জ নাম্বার অফ নন জয়নিং সিটস ভ্যাকান্টস রয়েছে, সেগুলো
লার্জ নাম্বার অফ
নন জয়নিং সিট ভ্যাকান্ট রয়েছে, মানে জয়েন করেনি, সেইগুলো ফিল আপ করা হয়নি। এবার ফার্স্ট অ্যালিগেশন যেটা ইনএলিজিবল ক্যান্ডিডেটদেরকে মেরিট লিস্টে ইনক্লুড করা, এটার জন্য আমাদের প্রথম
just a minute. Inclusion of ineligible candidates
in merit list.
Second allegation,
Marks manipulation.
One matter, number 34, is fixed. Yeah, and we keep not to do.
what is the item number? Your other side is here. Then ask any of your friend to respond. Marks manipulation. Next,
Reservation policy violation.
next,
নন জয়নিং সিটস ফিল আপ করা হচ্ছে না। নন জয়নিং সিটস,
that is যারা জয়েন করেননি,
হ্যাঁ যারা জয়েন করেনি এবং
যেগুলো যে সিট গুলো এখনো ভ্যাকেন্ট আছে,
হ্যাঁ, এবং এটা লার্জ নাম্বার, প্রায় নিয়ার অ্যাবাউট 30%।
হোয়াট ইজ ইয়োর গ্রিভান্স? আপনার অভিযোগটা কি? মানে আপনি এই মামলাটা কেন ফাইল করলেন?
এখান থেকে আমরা ডিপ্রাইভ হচ্ছি, মানে ফার্স্ট প্যানেলে আমরা ইনক্লুড হতে পারতাম। প্রথম কথা হচ্ছে ফার্স্ট প্যানেলে ইনক্লুড হতে পারতাম, সেটা হতে পারিনি। আর সেকেন্ড হচ্ছে নন জয়নিং সিটগুলো ফিল আপ হলে সেখানেও অনেকে ইনক্লুড হতে পারতো, ইনক্লুডিং মি।
বলুন কিভাবে আপনি হতে পারতেন?
ফার্স্ট অ্যালিগেশন যেটা ইনএলিজিবল ক্যান্ডিডেটদেরকে মেরিট লিস্টে ইনক্লুড করা, এবং সেটা না করলে আমরা সেখানে প্লেস হতে পারতাম বা ইনক্লুড হতে পারতাম। ফার্স্ট অ্যালিগেশন যেটা, সেটা ডিসকাস করার আগে মাই লর্ড, এলিজিবিলিটি ক্রাইটেরিয়াটা আমাদের প্রথমে জানতে হবে। মাই লর্ড, রিটেন টেস্টে অ্যাপিয়ার করার জন্য বেঙ্গলি মিডিয়ামের জেনারেল ক্যাটাগরির ক্যান্ডিডেটদের যে এলিজিবিলিটি ক্রাইটেরিয়া ফিক্স করা হয়েছিল, সেটা মিনিমাম 68.5% মার্কস ইন মাধ্যমিক অর ইকুইভ্যালেন্ট এক্সামিনেশন। My lord, please see affidavit in opposition, page number 10. Page number 10, affidavit in opposition.
Affidavit in opposition, page number 10.
এখানে এলিজিবিলিটি ক্রাইটেরিয়া ট্যাবুলার ফর্মে আছে, একদম লাস্ট।
মিডিয়াম বেঙ্গলি,
হ্যাঁ, ফার্স্ট রো 68.5% মার্কস।
68.5 marks in written test.
মাধ্যমিকে 68.5
পার্সেন্টেজ মার্ক।
হ্যাঁ, এই পার্সেন্টেজ মার্কস সেটা পেলে রিটেন টেস্টে অ্যাপিয়ার করতে পারবে, মানে অ্যালাউ করবে।
ও eligibility for criteria to appear in written selection.
Written selection test.
Okay. That is আপনি কি জেনারেল ক্যাটাগরির মধ্যে পড়েন?
হ্যাঁ, জেনারেল ক্যাটাগরি। এবং মাই লর্ড বেঙ্গলি
জাস্ট মিনিট, জাস্ট মিনিট। ইয়েস।
মাই লর্ড বেঙ্গলি মিডিয়ামের জেনারেল ক্যাটাগরির এমপ্যানেল ক্যান্ডিডেটদের মধ্যে যারা এই এলিজিবিলিটি ক্রাইটেরিয়া ফুলফিল করতে পারেনি তাদের কয়েকজনের লিস্ট দেওয়া হয়েছে। এফিডেভিট ইন রিপ্লাই বাই পিটিশনার, পেজ নাম্বার 6, অ্যানেক্সার P9, পেজ নাম্বার 6।
Page number 6.
My lord, please see column of academic marks. My lord, বেঙ্গলি মিডিয়ামে জেনারেল ক্যাটাগরির ক্যান্ডিডেটদের যাদের একাডেমিক মার্কস 7.23 কম তারা প্রত্যেকেই ইনএলিজেবল এবং মাধ্যমিকে 68.5% মার্কস পায়নি। এবং এই একাডেমিক মার্কসের সাথে এলিজিবিলিটি ক্রাইটেরিয়ার একটা রিলেশন রয়েছে, তার একটা ক্যালকুলেশন আমার কাছে আছে। মাই লর্ড প্লিজ সি।
I'll see, but আপনার এইটা নিয়ে কি বক্তব্য অ্যানেক্সার P9 নিয়ে?
মানে ইনএলিজেবল ক্যান্ডিডেটদেরকে মেরিট লিস্টে ইনক্লুড করার জন্য যে সিটগুলো ভ্যাকান্ট থাকতে পারতো, মানে যেখানে আমরা
ইনএলিজিবল, এরা ইনএলিজিবল কিভাবে বুঝতে পারছেন সেটা আপনি?
সেটা মাই লর্ড এই ক্যালকুলেশনটা দেখলে বুঝতে পারবেন।
তো এই পেজ 6 এ আপনি কিভাবে বলছেন?
পেজ 6 ওখানে যে একাডেমিক মার্কসের কলাম রয়েছে,
হ্যাঁ,
সেই একাডেমিক মার্কসের সাথে এলিজিবিলিটি ক্রাইটেরিয়ার একটা রিলেশন রয়েছে। এবং আমি ওটা এফিডেভিট ইন রিপ্লাই দিয়েছি।
নেম, ফাদার নেম, অ্যাড্রেস, ডেট অফ বার্থ, সাব ক্যাটাগরি, ওয়েমার, সাবজেক্ট মার্কস, ইন্টারভিউ মার্কস।
হ্যাঁ, নেক্সট, হ্যাঁ ইন্টারভিউ মার্কস। নেক্সট হচ্ছে একাডেমিক মার্কস।
একাডেমিক মার্কস
মিন্স হচ্ছে এটা মাধ্যমিকের মার্কসের উপর ডিপেন্ড করে এবং সেটার একটা ক্যালকুলেশন এখানে রয়েছে।
দেখি কি আছে। এটা কি বলছে?
মানে 7.23 কম হলে তারা যে ইনএলিজেবল সেটা ওখানে প্রুফ।
Therefore, those unreserved candidates whose academic marks below 7.23 should not be eligible for appearing in the written test. এটাকে আপনি আপনার এফিডেভিট রিপ্লাইয়ের সঙ্গে অ্যাডিশন করেননি কেন?
এফিডেভিট ইন রিপ্লাই ওখানে দেয়া রয়েছে মাই লর্ড, ওটা শর্ট দেয়া রয়েছে একটা।
মানে এই যে
এটা দেয়া
ক্যালকুলেশন অফ একাডেমিক মার্কসটা, এটা কারা তৈরি করেছে?
এটা এটা আমি ক্যালকুলেশন করে ওখানে দেখিয়েছি, এইভাবে ক্যালকুলেশনটা করা হয়েছে সমস্ত একাডেমিক মার্কস গুলো।
Therefore, এটা আপনার তৈরি করা?
হ্যাঁ, এবং এফিডেভিট ইন রিপ্লাইও ওটা আমি মানে সেইভাবে করা রয়েছে। এফিডেভিট ইন রিপ্লাই মাই লর্ড, পেজ নাম্বার 3, পয়েন্ট নাম্বার 10।
মাধ্যমিকে 8টা পেপার,
ইয়েস
মাধ্যমিকে 8টা পেপার 100 করে,
ইয়েস লর্ডশিপ।
তাহলে 548 মার্কস হলো টোটাল, 68.5% হচ্ছে, তাহলে 548। তাহলে যদি অ্যাডিশনালি 100-ও পায়, তাহলে 34 মাইনাস 66 হচ্ছে 548। একাডেমি মাইনাস অল কম্পালসরি হচ্ছে, তারপরে অ্যাডিশনালি মার্কসটা ধরা হবে না।
নো,
তারপরে অ্যাডিশনাল এসে 0ই পাক আর 100 পাক, দ্যাট ম্যাটার্স নাথিং।
না অ্যাডিশনালে যদি 100 পাই মাইলক্স, তাহলে সেখান থেকে 34 থেকে মানে 100 থেকে 34 মাইনাস হবে, হয়ে যেটা হবে সেটাকে 8 দ্বারা ডিভাইড করলে যে পার্সেন্টেজটা হবে, মানে সেই পার্সেন্টেজটা,
তাহলে এটা -66, এটা তো +66 হবে নাকি?
না মানে ওটা হচ্ছে গ্র্যান্ড টোটাল থেকে ওইটা বাদ যাবে, গিয়ে হচ্ছে মানে যেটা কম্পালসারি পেপারে অ্যাডিশনালটা বাদ যাবে তো। হ্যাঁ
মানে
হ্যাঁ মানে
অ্যাডিশনাল পেপারে 0ই পাক আর 100ই পাক, দ্যাট ইজ, সেটা কোনো ব্যাপার নয়।
না, হ্যাঁ কম্পালসারি পেপারে যে মার্কসটা পাচ্ছে সেটার উপর 0.12 মাল্টিপ্লাই করে একাডেমিক মার্কসটা ক্যালকুলেট করা হচ্ছে। অ্যাডিশনাল পেপারে মার্কসটা অ্যাড হবে না।
সেটাই তো বলছি,
হ্যাঁ হ্যাঁ ইয়েস লর্ডশিপ।
অ্যাডিশনাল পেপারের মার্কসটা অ্যাড হচ্ছে না। তাহলে 8.22 থেকে নিচে হলে উইল নট বি এলিজিবল।
এখানে ইম্পর্টেন্ট একটা পয়েন্ট, যে যাদের একাডেমিক মার্কস 7.23 থেকে 8.22 মধ্যে রয়েছে মেরিট লিস্টে, সেরকম ইনএলিজিবল ক্যান্ডিডেটদেরকে আমরা আইডেন্টিফাই
আপনি
করতে
এই
পারি।
জায়গাটা একটু পড়ুন প্যারাগ্রাফ। সিমিলারলি ইফ এ ক্যান্ডিডেট গেট 0 to 34 in addition his academic marks will be 8.22, 5 point into divided by into 12. Why it has been multiplied with 12?
12 academic marks, full marks awarded for this examination. মাই লর্ড, এই রিক্রুটমেন্টে টোটাল যে মার্কস অ্যালটমেন্ট করা হয়েছিল
Yes.
50-র মধ্যে, তার মধ্যে 20 ছিল ওএমআর, 10 প্যারা সাবজেক্ট মার্কস। My lord, please see,
Just a minute. Yes.
please see page number 3 of writ petition, main writ petition. ওখানে মার্কস অ্যালটমেন্ট গুলো দেওয়া রয়েছে মাই লর্ড। একাডেমিক মার্কস 12।
Yes.
My lord, এখানে যাদের একাডেমিক মার্কস 7.23 কম, তাদেরকে আমরা আইডেন্টিফাই করতে পেরেছি। কিন্তু যাদের যে সমস্ত ইনএলিজেবল ক্যান্ডিডেটদের একাডেমিক মার্কস 7.23 থেকে 8.22-র মধ্যে, তাদেরকে কিন্তু আইডেন্টিফাই করা যাবে না, কারণ তাদের যে মানে মাধ্যমিকে অ্যাডিশনাল পেপারে কত মার্কস পেয়েছে সেটা আমরা জানি না। আমি যদি একটা এক্সাম্পল দিই তাহলে মাই লর্ড বুঝতে পারবেন। একজন জেনারেল ক্যান্ডিডেট, সে যদি 68% মার্কস পায় এবং সে তাহলে ইনএলিজেবল হবে। কিন্তু সে যদি অ্যাডিশনাল পেপারে 74 মার্কস পায়, তাহলে সে অ্যাডিশনাল পেপারে অ্যাড করছে 74 মাইনাস 34, অর্থাৎ 40 মার্কস। তাহলে সেটা পার্সেন্টেজে ডিভাইডেড বাই 5%, তাহলে তার অ্যাকচুয়াল মার্কস,
আপনি তো বললেন অ্যাডিশনাল পেপারের নাম্বারটা এখানে একাডেমিক মার্কসের সঙ্গে
অ্যাড হবে না। এবার সেই 5% মার্কসটা মাইনাস হবে। 68 থেকে 5% মার্কস মাইনাস হলে 63% তার মার্কস উইদাউট অ্যাডিশনাল পেপার। এবং এই 63%-এর সাথে যদি 0.12 মাল্টিপ্লাই করা হয়, তাহলে 7.56 তার একাডেমিক মার্কস, অর্থাৎ 7.23-র অ্যাবাভ, কিন্তু সে ইনএলিজেবল। এবং মাধ্যমিকে সে 68.5% মার্কস পেয়েছে। তার মানে যাদের 7.23 থেকে 8.22-র মধ্যে রয়েছে, সেই সমস্ত ইনএলিজেবল ক্যান্ডিডেটকে আমরা আইডেন্টিফাই করতে পারবো না। 7.23 থেকে 8.22,
7.23
টু 8.22।
এটা আনআইডেন্টিফাইড।
হ্যাঁ, এখানে মেরিট লিস্টে মাইলর যদি মাধ্যমিকের মার্কস উইথ অ্যান্ড উইদাউট অ্যাডিশনাল সেটাকে যদি ডিসক্লোজ করা হতো, তাহলে সেটা আইডেন্টিফাই করা যেত। এবং রিসেন্টলি সাউথ 24 পরগনাসের মেরিট লিস্টে ওরা একটা অ্যাডিশনাল কলাম অ্যাড করেছিল, পার্সেন্টেজ অফ মার্কস উইদাউট অ্যাডিশনাল, সেটা শুধু একাডেমিক মার্কস ক্যালকুলেশনের জন্য। কিন্তু ওরকম দুটো কলাম থাকলে আমরা আইডেন্টিফাই করতে পারতাম, কিন্তু সেটা আমাদের পক্ষে পসিবল হবে না, এরকম কতজন ক্যান্ডিডেট রয়েছে। তো এই সমস্ত ইনএলিজেবল ক্যান্ডিডেটকে ইনক্লুড করার জন্য আমরা ডিপ্রাইভ হয়েছি মাইলর। এরপর সেকেন্ড যেটা অ্যালিগেশন যেটা আসছে মার্কস ম্যানিপুলেশন নিয়ে। ইয়েস, মাইলর, মার্কস ম্যানিপুলেশনের জন্য আমার এই দুটো মেরিট লিস্ট আমি সাপ্লাই করতে চাই। একটা নর্থ 24 পরগনাস 2009 আর একটা সাউথ 24 পরগনা 2009। এবং এটা জেনারেল ক্যাটাগরির মেরিট লিস্ট, কারণ এখানে অনেক ইনফরমেশন আছে যেগুলো মানে মানে বলার সময় হয়তো লাগবে মাইলর।
কিন্তু এইগুলো এইভাবে কিভাবে নেওয়া যাবে? আপনি তো এগুলো এফিডেভিট না দিলে তো কি এগুলো হবে কি করে?
আচ্ছা,
আপনাকে যা কিছু করতে হবে তো এফিডেভিট করে বলতে হবে, সো দ্যাট হি ক্যান কাউন্টার।
ইয়েস, ইয়েস মাই লর্ড।
সেই কারণে আমি জিজ্ঞেস করছিলাম যে আপনি কি এটা পারবেন?
এগুলো ক্রেবলি আকারে দেওয়ার মানে ব্যাপারে করা হয়েছে।
তুমি চার্ট প্রিপেয়ার করে এফিডেভিট করে করতে কপি দাও, যদি কিছু বলার থাকে।
আপনি আপনি কেন লিগ্যাল অ্যাসিস্ট্যান্স দিচ্ছেন না কেন?
Earlier, advocate was engaged in this matter, my lord. I don't
অন
know.
অ্যাকাউন্ট অফ ফিনান্সিয়াল স্ট্রিনজেন্সি, মানে টাকা পয়সার ব্যাপার একটা আছে কি?
Not not at all, my lord. Some problem facing.
না, দুটো কারণে মানুষ লয়ার অ্যাপয়েন্টমেন্ট করেন। একটা হচ্ছে একটা অর্থনৈতিক কারণে, আর 2 নম্বর হচ্ছে যে আপনার লয়ারের প্রতি ভরসা নেই। এছাড়া কোনো তৃতীয় কারণ থাকলে সেটা আপনি কোর্টে বলুন।
My lord, আমার
কারণ এই মামলাগুলোর যেরকম টেকনিক্যালিটি আছে, যেমন আপনি ওইগুলোর উপর রিলাই করতে চাইছেন আপনার মামলাটাকে সাবস্ট্যান্সিয়েট করানোর জন্য, আমার তো মনে হয় একজন লিগ্যাল পার্সোনালের আপনার হেল্প দরকার, যারা হাইকোর্টের নিয়ম কানুন বা প্রসিডিউর গুলো সম্পর্কে অবহিত।
আমার যিনি লয়ার আছে আমি ওনাকে কি মানে
Lawyer already
হেল্পের জন্য
engaged.
মানে আমি ওনাকে কি কল করতে পারি?
হ্যাঁ, নিশ্চয়, কেন করবেন না? আপনার লয়ারকে আপনি কল করবেন কেন? আমি আটকাবো?
মাই লর্ড, এগুলো তাহলে আমি এভিডেভিট নেক্সট হিয়ারিং এ দেখব।
You consult with a lawyer. If you say that you have financial stringency, this court has every power to appoint any lawyer on your behalf. and I can regularize the appointment through the Calcutta High Court Legal Service Committee. That I also can do. কিন্তু এই টেকনিক্যালিটির জন্যই আপনি অনেকদিন ধরে তো কোর্টে ঘুরছেন না, শুধু শুধু মামলাটা তো হয়ে যেতে পারতো আজকে।
মাই লর্ড, আমার যিনি লয়ার আছে আমি ওনাকেই মানে এখানে
বেটার
আর
আপনি
এখানে
লয়ারের সঙ্গে নিন, নালে এই যেমন ধরুন আপনি ওইটাকে বলছেন যে আপনার এটা খুব ভাইটাল ডকুমেন্ট, কিন্তু ওটা ওইভাবে ফাইল করা যাবে না। ওটাকে করতে গেলে আপনাকে একটা সাপ্লিমেন্টারি এফিডেভিট করতে হবে, সেটাকে কাউন্টার করবার স্কোপ দিতে হবে আপনার আদার সাইডকে।
আমি
হবে না আপনি হিয়ারিং এ
বলেছিলাম
আসতে পারবেন?
ব্যাপারটা করার জন্য, কিন্তু ওনারা বললেন ক্রেবলিপ আকারে দেয়া যেতে পারে, এই কারণে এটা এভিডেভিটে তখন দেয়া হয়নি।
আন্দাজে মামলা হয় নাকি আপনার কাছে? তো
না, আমি
যদি আপনার মনে
বলেছিলাম
হয়
হয় না
স্ট্রং
সেই
কেস
সময়।
হয় তাহলে তো আপনি করবেন। এটা আপনি যদি এফিডেভিট ইন রিপ্লাইয়ের সঙ্গেও দিয়ে দিতে পারতেন তাহলেও একটা কথার কথা ছিল।
New documents.
নিউ ডকুমেন্ট মাই লর্ড, এটা মেরিল লিস্ট, আমাদের যেটা মেরিল লিস্ট পাবলিশ হয়েছে সেই মেরিল লিস্টটাই।
আপনি এইটা ক্যালকুলেশনটা করেছেন, এটাও তো আপনি, এটার উপর আমি কিভাবে জুডিশিয়াল নোটিশ নেব?
মাই লর্ড, ওই এভিডেভিটে আমরা যে রিপ্লাইটা দিয়েছিলাম সেটাকে একটু ব্রেক করে দেয়া, সেম জিনিস রয়েছে ওখানে।
ঠিক আছে, আমি সেটা দ্যাট আই আন্ডারস্টুড যে হাউ ইউ হ্যাভ অ্যারাইভড দ্যাট ক্যালকুলেশন ফর মাই বেনিফিট, persuasion and understanding you have given it.
Yes, ma'am.
But when you rely on that, what do you want? You want to consult your lawyer, take assistance of your lawyer.
Yes, Lordship.
You don't have any financial stringency. আপনি কি করেন?
Unemployed.
তাহলে কিভাবে করবেন?
আমি আমার লয়ারকে অ্যাপয়েন্টমেন্ট, যিনি লয়ার আছে ওনাকেই তাহলে আমি।
তাকে তো ফিস দিতে হবে, সেটা কি আপনি পারবেন?
Yes, Lordship.
যদি না পারেন বলুন, I can stand by your side so far as the assistance is concerned.
Yes, Lordship, মানে আমি ওটা ফিস দিতে পারবো। তোমার কিছু টেকনিক্যাল এর ব্যাপারের জন্য একটু প্রবলেম হয়েছিল, সেই কারণে নিজে মানে আমি পিটিশনার ইন পার্সন হিসেবে এটা।
তাতে কোনো বাধা নেই, আপনার মামলা আপনি নিজে করতেই পারেন, তাতে কোনো বাধা নেই। কিন্তু আমি যেটা ফিল করছি যে আপনি ঠিক যেভাবে মামলাটা করা দরকার সেইভাবে ঠিক করতে পারছেন না। মানে এখনো পর্যন্ত যেগুলো বললেন ঠিক আছে, কিন্তু এই যে টেকনিক্যালিটি আপনি এগুলোর উপর রিলাই করছেন, এইগুলো একটু সমস্যা ক্রিয়েট করে যাচ্ছে। তো
মাই লর্ডশিপ, আরো কয়েকটা অ্যালিগেশন, যেগুলোর অ্যালিগেশন রয়েছে তার অলরেডি এফিডেভিট ইন রিপ্লাই বাই অপোজিট পার্টি সেখানে রয়েছে, সেই পয়েন্টটা নিয়ে যদি একটু।
না, ওইভাবে পিসমিল সিয়ানানি করে তো লাভ হবে না, আপনাকে করতে গেলে পুরোটাই শুনে নেবো।
লর্ডশিপ, তাহলে
কি আমি আপনাকে অ্যাডজর্নমেন্ট দেবো?
ইয়েস লর্ডশিপ।
The writ petitioner is present in person. Stop. An advocate for the state is represented. Okay.
Well,
in course of hearing.
I am appearing on behalf of the District Primary School Council, not to his Sorgana, madam.
And who is for the state then?
No, madam. He's along with.
ও তাহলে ওটা লিখে দেবেন, সাপ্লাইতে নেন। In course of hearing, it appears to this court that the present petitioner is facing difficulty on account of some technicalities. It is learned from the petitioner that previously he was represented by his lawyer, and thereafter for some reason or other he has decided to plead his case in person. However, on being asked, the petitioner personally submitted before this court that he is agreeable to take assistance of his lawyer in doing the case, and though he is unemployed, he is able to bear the fees of his lawyer. Stop. Paradigm. Considering the financial stringency of the petitioner, this court has communicated the petitioner that since the present petitioner has practically got no income, he may be provided with a lawyer of his choice from the panel of Calcutta High Court Legal Services Committee. But the petitioner communicates that in this case, he will again appoint his previous lawyer. Stop. Such being the position, the instant case is adjourned today. কবে রাখবো বলুন?
Lordship, as you wish.
Let the matter be listed on February 27, 2024 under the same heading.
Grateful, Lordship.
এই নামটা দিয়েছিস?
Item 48.
Lordship, I am appearing for the petitioner. I led by Mr. Prosenjit Mukherjee, advocate. He has instructed me to not to do the case, but if you permit, I will
do the case without the instruction of your senior.
I have gone through the brief, and I am
the other side.
On the last occasion, they are appearing.
Who is your senior?
Mr. Prosenjit Mukherjee. Yesterday, he was appeared.
What is your good name?
Samrat Banerjee.
Regarding Mr. Banerjee, learned advocate for the writ petition is present. None appears on behalf of the respondents. Though Mr. Banerjee expresses his willingness to proceed with the hearing today, but for ends of justice, this court is not inclined to take up the matter today in absence of the respondents. Since on the last occasion, respondent number 1, 2, 3, and 5 and respondent number 4 are represented by their respective learned advocate. Stop. Let the matter be listed on February 27 under the same heading. Learned advocate for the writ petition is requested to intimate the next date of hearing to the learned advocate for the respondent numbers 1, 2, 3, and 5 and respondent number 4, preferably by issuing a written notice, and to file the receipted copy of such notice on the adjourned date. Let them get a chance. Next.
49.
Not yet.
Who is the other side, sir?
Yes,
Oh,
others are waiting since long morning. And it is my default, but I did not appear day before yesterday, missing your lordship's list quietly. And your lordship is kind enough to give me a chance to argue with you. But this is my reply against the opposition filed by my learned senior friend.
49 Lordship praying for 5 minutes password.
ঠিক আছে আমি বলে নিই 5 মিনিটের মধ্যে স্যার চলে আসবে লর্ডশিপ
What about the service upon added respondent number 6?
Service affected
And he's
coming.
Gautam
Mr.
Banerjee.
Banerjee is coming. He is also waiting since morning. He is coming.
Respondent number 6, let me see once.
Yes. ডাকছে নাকি একটুখানি ফোন করে ডাকুন
Purvosthali to cooperative agriculture, it was hard previously, no?
Already your lordship almost was of the view that we are entitled to, but since nobody appeared in respondent 6, their version is to be heard. For that your lordship kindly see the 12th December order. On that day, extensive argument we have made, and Mr. Naik also made. 102 of the Cooperative Society Act was considered. They took the preliminary view, argument that it is not maintainable. But can you remember in court number when your lordship was sitting in 33? Oh, sorry,
It was
29. 29. And your lordship also gone through that now no writ petition is maintainable. Only to hear the respondent number 6, my employer. This matter was adjourned on that day.
You are appearing on behalf of this, sir?
Yeah.
Respondent number 5.
5. Yes, ma'am. And they have taken the plea in the opposition only ground of delay. But delay has not been caused due to subsequent cause of action arises directing them to consider our case. So at that point,
Mr. Gautam Banerjee, he will come.
Number 6.
He will come.
He is coming. He was there. All along first half, he was there. Let me place my case in the short manner. Your lordship can recollect the entire state of affairs in this matter. Page 14. We are the employee of that particular respondent number 6. Now we have been posted in a cold storage. We work there. Thereafter, page 17.
Deputed to cold storage unit of the society.
Yes, we work there. In the meantime, under that cold storage was another loan. Now, page 17. That out of the sales proceed, we are entitled to get our apportionment of our share, salary. Page 17. It is the letter issued by Assistant Registered Cooperative Societies.
What does it say?
Kindly see. With reference to the above, I would like to inform you that after series of postponement of sales in such and such, and sold an auction on such and such in 2010 at price 92 lakhs. It may kindly be noted that the reserve price for such and such, including certificate, demand, and government dues and claims on such and such, the certificate holder agreed to lower down the reserve price such and such. Now, column number 5 is our case. Demand of area salary and compensation of the employees of the society of rupees such and such. In this connection, copies that proportion apportionment of that salary also includes that including this distribution of proceeds of chutney consolidation. Now, next
this is the proposed apportionment.
Yes.
So for the purpose of area salary and compensation,
it is to be
17,60,000 has been kept aside. Kept aside.
Grateful. Already your lordship on that date your lordship already was of the.
No, please.
Now
please repeat your submission.
Yes, page 18.
Yes.
Next document.
Due salary, same amount.
Same. And 18 is the that.
So what is page number 18 that is
already
given?
Admitted. Now page
just,
number.
Just a minute, sir. Just a minute.
Well. This is the Joint Secretary, Government of West Bengal. Next page. I believe, my lord, if page was not there, therefore your lordship sports was pleased to direct me to give the second page, 18A. দিয়েছো তো?
That he has given?
Yes. Already there. I
Where?
believe so. In the separate sheet, my lord, it was given. Since it was found earlier, I could not retrieve. আরেকটা কপি আছে কি? Well, kindly take my copies.
No, if it has been given, probably it was given, I understand.
It is the letter issued by Joint Secretary to the Government of West Bengal.
Approval was given?
Yes. Apportionment of sale proceed of Chatni cold storage unit, Purbostali, when a subject is there, and then apportionment amount also there. Column number 5.
Give your copy, sir.
My lord, kindly take second copy.
Second page of that letter. No?
Second page of that copy.
Copy of the page, sir.
Let me see what is there.
Copy of the page.
কোনটা?
Page of the along with the copy of the sheet, page second number.
আপনাকে দেওয়া হয়েছে কপি কই? এই যে আপনার রিসিভ কপির মধ্যে বলা আছে যে
দেখি আমি একটু পড়ে দেখি।
হ্যাঁ দেখে নিন।
এফিডেভিট যখন করেছি না, এটা আপনাকে
এফিডেভিটের সঙ্গে এফিডেভিট
নিয়ে নিন না, নিয়ে নিন।
দেখি একটু পড়ে দেখি।
নিয়ে দেখে নিন না, করুন।
ওই কপিটা স্যারের কাছে?
কপিটা নেই তোমার কাছে?
আছে।
কপি বার করে দাও।
So it is therefore kindly requested to offer his view
Yes.
with regard to the apportionment settlement of sale proceeds. So as stated earlier, on receipt of the matter will be referred to the Finance Department for their approval.
Yes.
Finance
that
has
means
approved.
sanction is there already by the Government of West Bengal itself, Joint Secretary. Now, my lord.
Just a minute. Yes.
Page 19. It is to the Assistant Registrar Cooperative Societies by the Joint Registrar Cooperative Society. Apportionment of sale proceed in favor of us. But it is an internal departmental.
No, I believe page 21 and 22 is irrelevant.
Grateful. Much obliged.
Page 2.
An amount of 5,34,420 has been was apportioned for payment to the employees.
Yes. Now, already your lordship, paragraph 4 indicated that other day.
Yes.
My lord, kindly remember this. So, my lord, this is we are entitled to. So now it is kept with the bank. My learned friend, client, I believe so.
So give it.
I leave it. My poor employee, my lord, only.
Let me submission. Entire submission is false.
Why?
Yes, let me submit first.
Very good.
Now it is there. My lord, I shall not open my mouth. And they will argue on the basis of their affidavit in opposition. They cannot, my lord, make any argument beyond the pleading itself.
What is their affidavit in opposition?
The opposition, they have said that it is the delay of more than 20 years. Therefore, we are entitled. And second plea.
Para.
Yes, para. Paragraph. Paragraph D.
Page
4. D1. This is the bank's page 4 of their opposition of respondent number 5. My lord, got the page 4.
Oh, affidavit in opposition,
Yes, of respondent number 5. It is affirmed on.
Just a minute, sir.
My lord. 24th day of February 2022. By one Omlan Bhattacharya. Last day, your lordship, they filed just 6 on 6. Because in the order sheet it is written, I have checked it up. Just February 6th order.
Affidavit in opposition on behalf of the?
This one number 5. Can
5,
you see the
yes.
order itself?
Page number 4.
Page number 4.
Just a minute. What they have stated?
Yes, column number D1.
Yes.
No one of the said employees, including the made any application to the bank for payment of dues, to the bank for his rendering his service, to the bank of the sales consulate on deputation during last. So therefore, since we do not made any application, therefore we are not entitled to last for 20 years. According to my understanding of this paragraph, it is there. So we have made a representation itself. Annexure. The authority already sent to them. It is not required by myself.
Yes.
Page 21, 22. Yes. And we made the prayer representation to the assistant registrar cooperative societies Purva Bhagavastali, my employer. Okay. আচ্ছা 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 আমাদের লেটার সাপ্লিমেন্টারিতে হ্যাঁ ওটা আমাকে কপি দাও and their opposition also they have stated E page 6 same tune giving that story which I have stated in my petition itself. Page 6 E part E narrating their explanation which I have stated that it is correct. There is no denial to that extent that we have made the statement incorrectly.
Made the representation to lawyers and it was sent to the authority concerned by the assistant registrar. Post 24/27 pista petition.
And page 10 ওটাই তো পড়েছেন অলরেডি it is the cracks the বলেছি my lord is on that
Yes, sir. What is your submission?
on page 10
But page 7 says that nothing left with the bank.
otherwise it's 17 page 18 of my petition are done honest if that is so if their contention is in the affidavit is correct then my page 17 18 and 20 22 is not redundant because it is a document of the authority concerned and government of West Bengal that we are not being paid.
My lord,
that is my submission. It is contrary to.
Yes,
my lord, I leave it to us, my lord. We are poor employee, my lord. We are small, meager amount. It is to be disbursed. Maybe delay, but amount is not admitted.
kindly look at paragraph number 2, page number 3.
You are the bank, no?
Yes, my lord.
Respondent number 5 bank.
Respondent number 5 bank. Yes. Page?
Page 2, page 3, paragraph number 2 of the writ petition.
But may I take your lordship's 10 minutes leave? Dear to my lord.
Page number?
Page number 3,
paragraph number 2.
Yes.
The Purvasthali 2 Marketing Cooperative Agriculture Marketing Society Limited constructed a cold storage at Satni with financial assistance from the West Bengal State Cooperative Agriculture and Rural Development Bank Limited. In short, it is Westcar Bank Limited. Cold storage was constructed from the
Taking loan from your bank.
yes, and I have taken loan from the NCDC.
Yes.
And the society had been incurring in loss during its operation. West Bengal State Cooperative Agriculture and Rural Development Bank took control of the said cold storage unit itself on lease from the society. 7 employees, including the petitioner herein of the marketing society, were deputed to run cold storage unit, and the petitioner was working therein as mechanic and the manager of the West Bengal State Cooperative Agriculture and Rural Development Bank, Satni Cold Storage, created staff pattern with thereof. Now, my lord, the thing is this, it is admitted position that Satni Cold Storage was constructed taking finance from the respondent bank. And since they could not, the society could not run the cold storage and even could not repay the loan, the bank took lease the said cooperative society in 1993. Take lease from the said cooperative society, that is Purvasthali Cooperative Marketing Society Limited. Kindly look at page 4, paragraph number 3. That in the year 2002, West Bengal State Cooperative Agriculture and Rural Development Bank Limited stopped functioning of the cold storage unit.
At that time, it was under your lease. It was under your control on the basis of lease.
On the basis of lease, but we have stopped function and surrendered the cold storage to the Purvasthali Marketing Cooperative Society Limited. The cold storage was handed over to the Purvasthali Cooperative Marketing Society Limited, and all the
Purvasthali Cooperative constructed a cold storage.
Taking financial
assistance from you.
Yes.
As and by way of loan.
Yes.
They could not repay the loan.
Yes.
You took over the property.
Yes.
Since it was more
on lease.
On lease.
Yes. I have run the society for a period 1993 to 2002.
What is the period of lease?
1993 to 2003.
1993 to
2003.
Yes.
Yes. And paid the entire salaries and dues to the said staff, which were in the 7 employees were in deputation of the said Marketing Cooperative Society Limited.
But the salary of the employees, including the petitioner, remained dues for years. That has been stated.
That is his submission. That is his submission. But
It's from the documents of the government also. Then
but they could not submit any evidence in support of their claim with the writ petition that any amount of the salary and provident fund are dues with the said bank till date. Even with the writ petition.
Then what is your contention with regard to the annexure P5?
No, I'm coming. Let me submit.
Yes.
Kindly.
So after 2003, you handed over the cold storage to the society?
To the society. That is lease period is over.
But the society did not take back the 7 employees.
Yes, they did not take back their employees. That is not my employees.
Very good.
They were in deputation with me during the lease period.
Yes.
They took back the said employees, and there is no claim. They alleged in the writ petition, but they did not claim to me that such and such amount is due. I have performed the duties in the cold storage for such and such period, but the writ petition, my payment, my salary, my provident fund is due to you. Please kindly pay. They didn't. There is no petition to the bank for the payment of arrears salaries of the petitioner till date. Till date. If I am the employer and he is the employee, so he should make application to me for his payment, raising the bill for his period. He did not get the said amount.
What happened thereafter?
Thereafter, kindly come to page paragraph number 2, page 3. I have read it. Kindly come to paragraph number 2, please. Kindly come to paragraph number 3, page 16 of Annexure 3P3, page 16.
Page
16.
Yes.
This is a letter addressed to the administrator. Since there is no management in the cooperative, the administrator was appointed to the said cooperative society. The assistant registrar is writing to the administrator of the cooperative society that this is to inform you that 7 employees of the marketing society list enclosed were deputed to cold storage unit of the society Satni, which was run on lease by the Westcard Limited since 1983. Now, as certificate case filed by the said bank against the marketing society for default of loan, Satni Cold Storage was put on auction and sold by the certificate holder, this Westcard Limited, to a private cold storage company on 19th July 2010. So, the cooperative society did not repay the said loan. The bank, being the cooperative society, filed a dispute case before the register of cooperative societies and got award.
In this writ petition, the writ petitioners have prayed for an order of mandamus directing the bank to repay their dues, alleged dues rather.
It is not mentioned in the prayer portion. The bank is to pay.
Bank is to pay.
I am submitting on my behalf.
Then why in your affidavit in opposition, why you have not annexed those documents to substantiate that you have paid the salary during the period of lease?
This is the case of 1993. The cold storage has been sold out. The cold storage has been handed over to the cooperative society. The cold storage has been sold out in 2010, and it is to a private dealer. Now it is, the documents are not with me so that I can prove. They are that if they have any claim, that such and such amount is not paid to them. They did not make any.
No, they have annexed document.
Where? No, nowhere there is any annexed document. They paid to me for their salaries. You find out the document. There is nowhere.
For recovery of the loan, bank itself sold the property. The bank, not the society. It was the bank sold the property.
My lord.
Not the marketing society sold it. The recovery of loan and others sold by the...
Sir, take your seat. If I require an assistant, I'll ask. They have annexed document that an amount of rupees 5,34,420 was apportioned for payment of the employees in your custody. Page number 22.
That is not payable by me. Where it is stated that the such and such amount is payable by me. Payable by the West Bengal State Cooperative Bank. Who said so? What is their authority to by saying so? I mean, let me submit, my lord. I am submitting one by one.
Yes.
Yes. Kindly come to Annexure 4. Annexure 4, page 17. My lord, first para. With reference to above, this is the letter of the Assistant Registrar to the Register of Cooperative Societies.
I have already gone through.
Let me submit, my lord. Kindly hear me. With reference to above, I like to inform that.
Sir, I'll not hear you on line by line because I have already gone through this paper. What is your submission?
My submission is this: the cooperative society sold the said, the bank sold the said cold storage at a price of rupees 92 lakhs. 92 lakhs.
They have admitted.
Yes. And the certificate.
Also their case.
Yes. And certificate demand was 1 crore 385 934. Now, the total arrears of the society to me, I am a secured creditor, that is the bank. Kindly look at my affidavit in opposition in paragraph. Paragraph number, page 17. That the said amount total dues to the cooperative society is out of total, the Satni Cooperative Society, the serial number 4. Satni Cooperative Cold Storage Limited. 43 lakhs 74,423 was the principal amount. Interest 1 crore 7,082. Principal recovery. Principal 743 lakhs 74,423 and interest 48 lakh 25,577 and waive the interest due to the cooperative society 77 lakhs. Now, I am the secured creditor according to the provisions of the Public Demand Recovery Act. Kindly look at section 26. Madam,
Yes.
Disposal of the proceeds of execution, my lord. Disposal of proceeds of execution wherever assets are realized by sale or otherwise in execution of a certificate, they shall be disposed of in the following manner. There shall be first be paid to the certificate holder the cost incurred by him. A. B. There shall in the next place be paid to the certificate holder the amount due to him under the certificate in execution of which assets were realized. Paragraph C, my lord. If there remains a balance after these sums have been paid, there shall be paid to the certificate holder therefrom any other amount recoverable under the procedure provided by this act, which may be due to him upon the date upon which the assets were realized. There is no, it is stated, if there is any balance, if any, there is no balance. I have incurred loss of rupees 77 lakhs in this case, which I have repaid to the NCDC for taking loan from them, from the said organization. Now the certificate holder claimed this amount of rupees 17 lakhs to the extended of cooperative societies. No employee prayer made any prayer.
Sorry.
No employee made any prayer to me till date. The
Prior to that, what you have
certificate holder intimated the extended of cooperative societies that such and such amount is dues, which is payable to the employees of the cooperative societies.
You are the certificate holder.
I am the certificate
holder.
Yes. Whenever realize certificate, no, this amount is payable to the employees of the cooperative societies. He cannot claim, he did not make any submission at the time of the dispute case which I filed before the register. He did not make any claim before the certificate officer. And the cold storage is sold out at a price of rupees 92 lakhs against my public demand, which is issued by the certificate officer as 1 crore 3 lakhs.
This I cannot follow.
Let me
Just
submit.
submit, sir.
Let
Just
me submit. In a certificate case, the certificate of demand notice is to be served by the.
I understand. Who is the certificate holder in the certificate procedure?
I am the certificate holder.
You are only that is I am telling you.
Society is the certificate debtor. Debtor claims that such and such amount is dues to the bank. Such and such amount is dues to the employees of the cooperative society. He did not say that such and such amount is payable by the bank to the cooperative society. And this cannot be.
After certificate
This
proceeding.
cannot be. This
Please answer to my question. After certificate proceeding.
Yes.
After squaring your debt.
Yes.
Anything amount remains
No
in the hand
balance
or not?
No balance. I have submitted the statement before Your Honor in annexure to the affidavit in opposition. Kindly look at page 17.
That you have seen. Just a minute.
Kindly look at page 17.
In the year 2000 and stopped functioning, the secretary, as a society could not repay its loan for construction such and such, the certificate was issued to ARCS. Was a demand. Please come to page number 17, vis-a-vis page number 22 of the writ petition. Page number 17 of your affidavit in opposition.
Yes.
Vis-a-vis page number 22 of the writ petition.
22 of the writ petition, my
Yes,
lord?
sir. 21 is the first page, 22 is the continuation page.
Yes, my lord.
Page number 17 is the statement of your demand and recovery.
Yes.
Am I correct?
Yes.
And page number 22 says the property was sold through auction on such and such date at a price of rupees 92 lakhs.
Yes, my lord.
So if it is sold at 92 lakhs, it must be shown in the recovery column.
Yes. I
Let
have shown in the recovery column.
Let me calculate it.
Kindly look at page 17 of my affidavit in opposition.
Let me look at it. Your amount is recovery 43 74 423 and 48 25 577. Yes, it comes to 92 lakhs.
Yes, my lord. And I have to waive interest of the said cooperative society. Purposely, my marketing cooperative is to the tune of 77 lakhs, 91,000. I have waived interest. There is no balance, my lord.
You are for the
Marketing society.
The dues of the bank was 43 lakhs 74,000 and odd, and interest was 1 crore 26 lakhs and 17,000. By way of a certificate proceeding, 92,000 was recovered.
92 lakhs.
92 lakhs was recovered. They have waived 77 lakhs, even that is still due. So how do you keep this amount in suspense account for the benefit of the employee?
My lord, at that point of time, now it is, after a lapse of so many years, there is so many changes in this.
No, it is a case of a pure arithmetical calculation. It is admitted position that the cold storage was sold at a price of rupees 92 lakhs. So far, the petitioner's contention is that they have got a confirmation from the cooperation department that rupees 5 lakhs and 34,000 has been kept for the arrears payment of the employee. The bank shows their annual statement with regard to the recovery of same amount, but still there is due with regard to the interest and principal amounting to 77 lakhs 91,000. So how do you justify this claim? So as per this certificate proceeding, their dues have not yet been cleared up.
Yes, my lord. And my lord.
Sir, please.
Yes, my lord.
Simply by getting a confirmation from the government that such and such amount has been kept in the suspense account for the benefit of the employee, that will not serve the purpose, because they have given their, on affidavit, they have given their annual report showing that 77 lakh 91,000 is still due.
And my lord, we have intimated the same in page, kindly look at page 14. And we said decision of the cooperative society was intimated to the Assistant Registrar of Cooperative Societies by the Managing Director of the bank. Kindly look at affidavit in opposition, page 14. And said decision has not been challenged yet in any court of law.
Your lordship kindly see page 21.
No, prior to that, I'm giving the answer, right? Page 18 first. They are showing the documents of 2010 in their opposition. 14, 15, 16, all are from 2010. Kindly come page 18.
Page
18. It is the letter written to from
18,
the
1/8.
1/8 of my petition. It is dated 3/5/2011. After their calculation, page 18 sees from Sri H.P. Roy, Joint Secretary from the Government of West Bengal. This is the Managing Director, West Bengal State Cooperative Agricultural and Rural Development Bank. My learned friends kindly sees. All this apportionment order has been passed after considering all these things. It is 2011 order. Here, due salaries, etc. of the employees of the society, 17 lakh something. They have considered thereafter this order passed. Now they cannot say that we have that document, therefore we proceed to all the basis of that page 17 onwards of that opposition. This is after this. And they have not said anything contrary to in the opposition itself. They have not denied this.
Who is RCS? Who is RCS?
Register of
He has no
IIPR person, one, two,
yes.
No one can.
That is admitted fact.
No one
Its
can.
yes
no
has
one
come
can,
with a
no one
proposal. That is a different thing.
That is it is admitted fact. They have not denied that we are
No
not
one has
entitled.
the authority to violate the law as provided in the Public
Denial, question of
Recovery Act.
denial does not arise.
So it is the between
92 lakhs have been recovered by way of a certificate proceeding. Their dues are much. They have accepted that amount after waiving their interest, and that has been communicated to the Purvastali. So how it becomes due?
Whether that waiver comes into play of my entitlement of the salaries, I am asking to myself. This, if they waive everything,
if there is nothing left to pay, how they will pay and why they will pay?
that is why that amount of 5 lakh, page 22 has been kept even then but said waiver. In the suspension, page, can you see page 22?
Is that the confirmation from the bank?
Yes.
It is not the confirmation from the bank.
On the basis of that letter of 2011?
On the basis of
But subject to
that is the letter of the RCS cooperative.
They have not denied
Register of
so.
cooperative.
It is letter
Who
to
is
the
register of cooperative society?
letter to the
Is there
managing
any
director.
authority? Is there
Thereafter,
any
Joint
authority?
Secretary, Government of West Bengal also.
Yes, that
settled this
confirmation has
matter.
been made to the bank.
And
itself.
Secretary Government of West Bengal is not the controlling authority of the bank.
Not the controlling, but
This bank is
if you
governed by
kindly
the
page
government, my lord.
clear.
I understand
West
I
Bengal
understand your case. Let me pass my order. Come.
Only one small submission, Lordship, because I am the 1, 2, 3. My affidavit in opposition is also there, Lordship. I placed on earlier location. Today, shall I paste or not required, Lordship?
Sorry?
Shall I paste my the statements or
Not required, not required.
not required? Only kindly refer that
You are not the answering. Yes, that I will do.
they have
That.
filed or affidavit in opposition.
Yes, yes.
Your lordship, I grant me leave, my lord. Grant me leave.
Please, please. Supply your name and
Yes.
take your seat.
Get.
The petitioner comma the respondent number 3 comma he was appearing on behalf of
6. Respondent number 6.
and you are for bank. Respondent number 5. এদিকে এসো বাবা।
6 and 7. Mr. Banerjee is for 6 and 7.
Property source agriculture and adjacent.
There is no 7, only 6. Kilogram petitioner, the respondent number 3, comma, respondent number 5, and respondent number 6 are represented by their respective learned advocates. Stop. By filing the instant writ petition,
My lord, 1, 2, 3 are also being represented. 1, 2, 3, 4. I appear for 1, 2, 3, 4.
1, 2, 3, 4.
Yes.
ও তাহলে রেসপন্ডেন্ট নাম্বার ওই যে 2, 3 বলেছি না, তাহলে 1, 2, 3, 4 করে দাও।
Lordship.
1, 2, 4 করে দাও।
1 to 4. Yes.
আচ্ছা, by filing the instant writ petition, the writ petitioner, by filing the instant writ petition under Article 226 of the Constitution of India, the writ petitioner has prayed for an appropriate order for release of his arrears salary, including others dues escaped in the suspense account of the respondent number 5 bank, on account of on account of sale in auction of Purvostholi - Roman 2 Cooperative Agricultural Marketing Society Limited,
Bank Limited.
Marketing Society,
Banking Society Limited.
Bank Limited.
Marketing Society Limited. Bank Limited.
Sir, let me pass my order. কি লিখলাম বলো তো? না আরেকটু বলো, উপর থেকে বলো। No, auction of a cold storage, ওটা রেখে দাও, of a cold storage constructed by Purvostholi 2 Cooperative Agricultural Marketing Society Limited, hereinafter referred to as the said society in short, being the respondent number 6 here. Stop para. It is contended on behalf of the writ petitioner that said cold storage was constructed by the respondent number 6 society after obtaining financial assistance from the respondent number 5 bank, and since the respondent number 6 authority, respondent number 6 society was incurring loss, comma, respondent number 5 bank to control and started to run the said cold storage on lease since 1993 till 2003. He said 2003, 2, make it 2. It is the further case of the writ petitioner that during the said period, the present petitioner, along with some other employees of the cooperative bank, of the said cooperative, worked in the said cold storage in deputation.
On deputation.
On deputation basis. On deputation basis. And that the salary of the writ petitioner and the other employees remain dues. Stop. Since the respondent number 6 society could not repay the loan, the said cold storage was auctioned at a price of rupees 92 lakhs. Drawing attention to annexure P5 to the writ petition and annexure P8 to the annexure 5 and annexure P8 to the writ petition, it is contended that a breakup was prepared by the Cooperation Department of Government of West Bengal with regard to the apportionment of the sale proceeds of rupees 92 lakhs, in which rupees 17 lakhs 63,220 was kept aside for payment of the due salaries and other dues as payable to the employees of the said cooperative who worked on deputation with the respondent number 5 bank. Stop. It is further contended that in spite of keeping the said amount of rupees 5,34,420, 5,34,420. No, I'm sorry. কি পড়েছিল পড়তো বাবা একটু আগেরটা লাইনটা পড়ো was proposed to be kept aside. Was proposed to be kept. আচ্ছা ওইখানে বলেছিলাম না annexure P5 and P6 টা কেটে দাও drawing further attention of this court to the annexure P6 নয় এটা P8 হবে P8
page 21, 22.
P8 it is submitted that that the respondent number 4 under cover of his letter dated 6/1/2020 addressed to the respondent number 5 bank confirmed that an amount of rupees 5,34,420 has been apportioned for payment to the employees of the said cold storage, and that was kept in the suspense account of the respondent number 5 bank. Stop. It is thus contended that the present writ petitioner, being the ex-employee of the said cold storage, is thus entitled to his proportionate dues upon the said sum of rupees 5,34,420. Learned advocate for the writ petitioner thus submits that an appropriate order may be passed for releasing the proportionate share of the present writ petitioner, which is still lying with the bank authority, that is the respondent number 5. Per contra, your good name, sir?
Malay Kumar Rai.
Mr. Rai, learned advocate for the respondent number 5 bank, at the very outset draws attention of this court to the draws attention of this court to annexure P8 of the writ petition, that is the letter dated 6/1/2020 as written by the respondent number 3 to the respondent number 5. It is contended that from the said letter, it has become crystal clear that for non-payment of the loan amount, a certificate proceeding was initiated, and on the basis of the said certificate proceeding, the said cold storage was auctioned at a price of rupees 92 lakhs. Mr. কি বললাম Mr. Rai না? Mr. Rai, course of this argument also draws attention of this court to the Annexure A1. No, sorry. Annexure, yes, Annexure A1. The affidavit in opposition as used by the respondent number 5, which includes annual report of the said bank for the year 2009-2010. from the annual report as placed before these four individuals, that as against the total dues of the bank that is rupees 43,74,423 towards principal plus rupees 1,26,16,08 towards interest. Totaling to 43,74,423 plus 1,26,17,08 totaling to rupees cash is sum of rupees 92 lakhs. Rupees 43,74,423 towards principal and rupees 48,25,577 towards interest have been recovered. The bank has, the respondent bank has still outstanding dues to the tune of rupees 77 lakhs 91,505, which the respondent bank has waived on the basis of the resolution as taken in the annual general meeting in the year 2009-2010. Stop. You know. In the year 2009-2010. Drawing attention to section 26 of Bengal Public Demands Recovery Act 1913, it is contended that since the dues of the respondent bank tantamounts to public demand recovery, under the law, the respondent bank, being the certificate holder in the certificate proceeding, is entitled to recover the following, namely, Roman 1, the cost incurred by the certificate holder. 2, Roman 2, the amount due to him under the certificate in execution of which the assets were realized. 3, any other dues which remains unpaid to the certificate holder. And 4, the balance, if there be any, shall have to be paid to the certificate debtor. Stop. It is contended that from the statement of accounts which has been placed and approved in the annual general meeting, it reveals that the entire recovered amount of rupees 92 lakhs as and by way of auction sale has been utilized for mitigating the dues of the respondent number 5 bank as a certificate creditor. And therefore, there cannot be any dues payable by the respondent bank to the writ petitioner. Stop. On perusal of the entire materials as placed before this court.
My lord, a few paragraphs from our affidavit, because we are 1 to 3. We are
not required for my disposal, Mr. Rai. On perusal of the entire materials as placed before this court. This court finds sufficient logic in the submission of Mr. Sarkar, Mr. Rai, learned advocate for the respondent number 5 bank, in view of the provision of section 26 of the said act. Stop. Before this court, the respondent 5 bank being the certificate holder has clearly indicated as to how the sale proceeds of the auction value of the
mortgage asset
of the cold storage have been utilized, and therefore in considered view of this court, the letter dated 6/1/2020 as written by respondent number 3 to as written by respondent number 4 to respondent number 5 is of little significance. Stop. This court is satisfied that the respondent number 5, being the certificate debtor, has clearly explained as to how the certificate holder, I'm data বলেছি, certificate holder, কি বললাম? This court is satisfied that as to how the sale proceeds of the auction has been utilized, and in considered view of this court, those are in accordance with the provision of section 26 of the said act. Stop. This court thus considers that the present writ petition is devoid of any merit, that this writ petition is thus devoid of any merit and is thus dismissed, but without any order as to cost. Urgent Xerox certified copy. Shall keep this book for some day.
Grateful, Lordship. But dismissed or disposed of? You will ask.
Dismissed.
Grateful, Lordship.